All rise, please. Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Massing. To my left, Justice Toone. We will be hearing 5 cases this morning. The rules are as they always are, which is 15 minutes per side with no rebuttal. If in any of these cases there is more than one party on a side and they will be dividing their time, you should let us know at the outset what the division is. We have read your briefs with some care and are familiar with the facts of each case, and so my recommendation to you is to get right into your arguments rather than spending time rehearsing the facts, but it is your time and you may do with it as you wish. So with that, we will hear first number 25-357. This is Commonwealth versus PENA. And we will hear first from Attorney Bennion.
To the presiding justice, and may it please the court. In 1789, when James Madison was preparing a draft of what would later be known as the Bill of Rights, there was concern that to write down certain rights might be in some future date to mean that non-written down rights, unenumerated rights, would be held in less esteem. And so the Ninth Amendment was written. Make no mistake, this case is not about a sexual assault. It is about the denial of a fundamental right to this defendant. He made a claim of lack of criminal responsibility, and the only way that a jury can really make that assessment is to look at the defendant, to gauge their personality, their traits. This is something we understand in the appeals court. We understand that witnesses are judged on their credibility by external factors. And whatever the jury kind of weighs, whether somebody shifts in their seat, whether they appear credible, these are not decisions, these are not reviewable decisions by this court.
Well, your client wasn't even in the courtroom for most of the time, right?
None of the time, except for the hour and 10 minutes that he testified.
Right. And the reason he was not in the courtroom is because he was dysregulated. He was even under medication. Well, do we know that he was under medication or not?
So the record seems pretty clear, and I can give you the citations, but they're in my brief. From the July, we have an affidavit from defense counsel who believes he was medication compliant, but we also have the July transcript dates, the 22nd, I believe, where there was testimony that he had been taking his medication.
Okay, so if he was not taking his medication,
That he was taking his medication, he was compliant.
But if you wanted him not to be taking his medication.
I don't want him on medication, that's right.
Right, so how can he come to the courtroom then?
So that's the tension of the case. On the one hand, we have a judge who wants to keep decorum in his courtroom. On the other hand, we have a fundamental right that this defendant has multiple times through his counsel expressed a desire to exercise, and that's the point of a right, is it restricts the government from doing exactly what it did. I understand, you can look at the verdict slips. There was a place where the jury could check mental incapacity, but if they haven't observed the defendant, except for the time where he was medicated and testifying, then it's not much help. We've all walked the streets of Boston. We understand that there is something innate in us as human beings that can determine whether somebody is mentally impaired or not. You see people like this on the streets, and we all make our own determinations, and that's what we're asking the jury to do. Now, there are certain ways that you can...
There was no expert testimony, right?
As to... No, there wasn't.
On the defendant's side. So the jury was being asked to make their own lay determination that he lacked criminal responsibility.
Absolutely. That is a right. That's Lorraine and other cases that are cited in the brief make that very clear. And even the words fundamental right. And Lorraine talks about the fact that this is a due process right under the Sixth Amendment, 14th Amendment, and under Article 12 of the Massachusetts.
There's no question there's a right, and I guess the question is, was this issue relevant here? And I see at least
Sorry,
two.
what was the question?
The issue is whether this was relevant here, and whether the preconditions for the motion were satisfied. And I think I see two problems. One, there doesn't appear to be any evidence that the defendant was unmedicated at the time of the alleged crimes. And two, you said that the defendant was medicated during trial, but the motion to permit the jury to see the defendant's demeanor in an unmedicated state twice states that indicates that he has not been medication adherent at the time of trial, that he was at Bridgewater, but then he was transferred to South Bay and he wasn't there. So I feel like on both of those, the condition at the time of the offense and the condition at the time of the trial, there seem big question marks as to whether either of those conditions were satisfied that would make the right applicable. Am I missing something there on the record?
So all that needs to happen to make a right applicable is for the defendant to claim it. It's up to the jury. The defendant can claim whether, and the reason you have conflicting statements, sometimes it seems like the defendant or the counsel wasn't, or was conflicted about whether whether the defendant was compliant or not, and even sometimes the medical staff were. And this seems to come from Mr. Pena himself. I get the same mixed messages from him, and it's very difficult to kind of ascertain. But there's nothing in the case law that says that to exercise this right, you have to show the defendant was either medicated or not medicated at the time of trial. The reason for the unmedicated state is to show him in his natural, the way he is naturally. Whether he was medicated or not, that's up to the jury to determine. That's a factual question.
Well, let's start with, I mean, don't you have to establish that he was not medicated at the time of the offense? Isn't that, if you're trying to show, if the idea is to show the condition, the mental status of the defendant at the time of the offense, there has to be some indication that he wasn't medicated at that time, right? And there wasn't anything like that in this record.
So Mr. Pena lived by himself, and he's not a great relator of his medication, taking his medications or not, his habits.
Any other evidence, though?
Right. So the idea is that if you can show him in an unmedicated state, even if he was in a medicated state, if you understand that he is mentally impaired, then that's for the jury to make the determination whether he was taking his medication at the time or not. But even if he was, we have testimony in the record that at least one person at Bridgewater said that and I'll actually just show it to you, and this is on 47 of my brief, referring to the July 7th, 2022 hearing. That medication may help with his behavior, but it may make very little difference, if any, in his overall mental state and ability to comprehend things. I mean, the problem here is that there's...
the risperidone.
I'm sorry?
You're talking about the risperidone, right? When that was a off-label antipsychotic, but apparently prescribed not for psychosis, but for behavioral issues? Is that what the record shows?
Yeah, there's no diagnosis. And while medication was given, it was given kind of on an ad hoc basis to kind of help deal with his symptoms. And it's those symptoms that the jury needs to see to make a determination whether he... I mean, to be in Mr. Pena's presence, nobody will question that he is mentally off. No one. In fact, the longer you spend with him, the more you understand this. I've known him now for 3 years. This was a almost 12-day trial. If you were to put Mr. Pena in before the jury to let him see him unmedicated, it's just 100% that the jury is not going to come back.
Yeah, I think the problem, I mean, obviously I see the problems that Justice Toone is describing, although I thought your answer to the first one would be he didn't have a prescription until he got one at South Bay, right? He didn't have, so far as we know, he didn't have any medication prior to getting this risperidol.
Right,
Isn't
we
that
don't know.
right?
That's not on, as far as I know.
Okay, so I would have thought that might be your answer to, was he medicated at the time of the crime? So far as we know, there's no indication he had any medication.
That's right. Or if he did, he was
The
even taking it.
problem that I think your case has to do with the nature of his mental condition. You did not put on an expert. No one diagnosed him with psychosis. He's taking an antipsychotic. Of course, we understand that a psychotic person on an antipsychotic will present differently. He did not have this for psychosis, and in fact, the prescribing, I think it was a nurse practitioner, said that it was for, I don't even remember, something about controlling his impulsiveness or something.
Impulsivity related to antisocial personality.
Yeah, I just don't see how you've made the case that he would have been different in any relevant way off of medication. I mean, if I'm not mistaken, I don't see any children here. If I'm not mistaken, the jury saw him take off his clothes and masturbate in his cell on a screen. That's, you say, when he was medicated, I guess. I just don't see any evidence that in a relevant way he would behave differently off of risperidol.
We don't know, because he wasn't.
Well, you could have gotten an expert. It's your motion, right? It's your burden.
It is our burden, but the burden was not to set up a clinical diagnosis. It's to let the jury just through their own lay perceptions understand.
I'm sorry, if I'm taking Advil because my knee hurts, the jury doesn't have to see me not on Advil, right? Not every medication, not every defendant has some right, abstract right, to be shown unmedicated. Don't you have to show that it was relevant to his behavior at the time of the commission of the crime? And wouldn't an expert maybe have been able or not able to do that?
So we have testimony from his friend who met him at South Station, who said that he was off. Again, the idea here is that Mr. Pena cannot control himself or is mentally impaired to the point where he can't be held responsible for this crime.
Because he doesn't know the difference between right and wrong.
So the difference between right and wrong is different. That's to stand trial. There's plenty of evidence.
All right, so what is the test for whether you have the competence to have known what you were doing when you committed a crime and be criminally responsible? What has to be shown?
It's a lack of mental, and again, the judge gave the instruction to the court, but it wasn't very helpful to them if they didn't understand what Mr. Pena is like.
What's the test, I asked you? Or ability?
Yes.
Well, I want to know, well, all right, well, we can look. Obviously, we have the instructions, so we know what they were instructed. I haven't looked at it, but we have it.
My mind's just going blank for the exact wording of the instruction. But it's a lack of responsibility or able to control his ability to comply with social norms. Again, whether he's unmedicated or medicated, it's important for the jury, especially when he's raised the defense of impairment, that the jury see him. This was a lengthy trial. The defense counsel was more than willing to talk with the court about ways that they could keep the jury safe. But to just remove him from the court to keep decorum in the courtroom was a violation of that fundamental right. It doesn't mean anything if the government can just whisk you away and have you view the proceedings by Zoom, and anytime you...
Wait, I thought your argument was he had to be presented in person while unmedicated, not that there was a problem with him having been removed from the courtroom. I don't remember.
So defense counsel at trial...
I'm asking what you argued here.
So my argument is based on the motions that defense counsel put up, and that is to be viewed unmedicated. He was viewed for the hour that he was testifying, but he does seem to be medicated at that time. But you need more than an hour of strictly controlled access to Mr. Pena in order for a jury to make this determination. If the importance of a jury is, when we're talking about just witness credibility, is to actually see the person, then it's an even more important point in this case that the jury can see the defendant. You have to be in his presence to understand his mania and in his manic personality.
What would you say, how would you express the test that needs to be satisfied in order for a defendant to be allowed to present him or herself in an unmedicated state? What needs to be, because it can't be every case, so what would your standard or test be?
Well, no, I think in any case where a defendant raises the right, where it's a fundamental right based on constitutional principles, the defendant gets to raise it. Now, this presents a problem. The government said that, oh, well, there's a problem that, it might be a mistrial, but I don't think you'd ever have a mistrial when the defendant's raising the issue.
But I mean, clearly, that's not, as Grodny says, that's not the case. It has to be relevant, right? So that's, I guess, it can't just be the fact that a motion is made. There has to be some kind of relevancy showing.
The relevancy here is the fact that the defense claimed it. It was presented in the testimony of the friend at South Station, and it was also presented through the victim that this person is mentally off. And so that allows him to raise the issue. Once he raises it, the court can't just take it away. It has to work with the defendant in order to make sure that the jury can see him. Again, if you spend time with Mr. Pena, you will see, and I just can't imagine that a jury who had spent 10 days with him would ever convict. I just don't see it.
All right, your time has expired, and I see no further questions from the panel, so thank you very much. We will hear next from Attorney Polenbaum, I hope.
Thank you. Good morning. May it please the court. Ian Polenbaum. I handled this case from the beginning through the trial. Defendant's fundamental right to prevent favorable proofs only extends to relevant evidence. The Lorraine decision from 1983, which is essentially the foundation of this appeal, did not declare a separate fundamental right to do what the defendant now says he should have been able to do. Lorraine was really a narrow evidence-based holding, never replicated in any appellate case as far as we can see, and I would suggest completely distinguishable from the present case. I'm going to argue that Commonwealth versus Colleran, in which the SJC 25 years later declined to follow Lorraine, the only time we can find where an appeals court was asked to follow Lorraine, the Colleran is on point. The Lorraine case did not say that any defendant claiming a lack of criminal responsibility in raising that defense has a due process right to be shown to the jury off medication. The Lorraine case was driven by several distinct facts about that defendant that were not true about Pena. First, that Lorraine had a mental illness with psychotic features. Victor Pena did not. The evidence, both before and during trial, wasn't just the absence of such a diagnosis. It was 5 experts saying that he did not, including one expert who testified at trial in rebuttal, that not only did he not have a mental illness with psychotic features, but that he feigned psychotic features when he thought it suited him.
So if he had presented an expert, a counter-expert, to sort of say, yes, he does have psychosis or schizophrenia or some other condition, that would have been enough to make the right applicable?
Well, only if, as in Lorraine, there was testimony that by the time of trial, Mr. Lorraine, number one, was on medication that he wasn't on at the time of the crimes, and number two, needed that medication to treat his psychotic symptoms so that he would have a grasp on reality. In fact, Lorraine was compelled to take medications in order to stay competent. And the medications were both prescribed and had the effect to treat Lorraine's psychosis. Again, Mr. Pena not only did not have a disorder with psychosis, but he wasn't prescribed the drugs to deal with psychosis. He was
The jury were instructed to determine whether he was criminally responsible. Did you object to that instruction?
Initially, yes, but ultimately, no. In other words, it was initially over our objection, but I think Judge Campo, I think, correctly allowed it, just as Judge Campo correctly
So there is
allowed it.
evidence in the record sufficient to allow them to make that finding.
Yes, under the standard that it is possible to present, I guess for lack of a better term, kind of a lay criminal responsibility defense. And the defense in this case, which defense attorney did an honorable job of trying to present with extremely thin support, was essentially somebody who acts like this and says these kinds of things, and in fact says the kinds of things he's digressed in during his testimony, that person can't be right, and that person can't have a grasp on reality. And I'll get to eventually, depending on how much time I spend, I do have the even if argument that even if Judge Campo made some kind of mistake with the unmedicated display and prohibiting it, that it wasn't prejudicial error because the evidence of criminal responsibility was so strong.
Before we get there, I want to understand your position as to what needs to be satisfied as preconditions before this right can, we all recognize it's a right under Lorraine. So before it can be exercised, you seem to say there has to be some kind of evidence that the defendant was in an unmedicated state at the time of the offense. There has to be evidence that the defendant is on the medication at the time of trial. There has to be evidence of a significant mental health condition that alters judgment or behavior, and there has to be a relationship between the medication and how the defendant exhibits that condition in a public setting. Do all four of those elements have to be satisfied under your test? 'Cause it seems like quite a lot for a defendant a lot of hoops for a defendant to have to go through to make an argument about a right that's recognized in the courts.
I would go farther on the fourth element that Your Honor listed, because it's not simply medication having an effect on presentation and behavior. It's medication having an effect on somebody's grasp of reality, and more to the point, their ability to appreciate the wrongfulness of their conduct and to conform their conduct to the law, whether they have that capability.
Well, those are disjunctive, actually. I'm looking at the instruction, at least as it was given. I don't know if this is right or wrong, but this is what the jury were, without objection, told to find. A person is not criminally responsible for his conduct if he has a mental disease or defect, and as a result of that mental disease or defect, lacks substantial capacity either to appreciate the criminality or wrongfulness of his conduct and to conform his conduct to the requirements of the law. So it doesn't say he has to have a grasp of reality. It doesn't say that, it doesn't even say that he has to not appreciate the wrongfulness if he can't conform his conduct to the law because of his mental illness. That also shows a lack of criminal responsibility, or it's proven the other way, right?
It does, Your Honor, but in this case, unlike in Lorraine, there was no suggestion even that the medication he was prescribed off-label had any effect on his ability either to appreciate or to conform. It was neither in the purpose they were prescribed for nor in the effect. The purpose they were provided.
What does impulsivity mean?
Impulsivity, the way the experts described it, were basically impulsivity in terms of his outbursts, impulsivity in terms of his hostile behavior, impulsivity in terms of his downright racist outbursts that he had both in the facilities, and it's part of the record in court that he had some comments about and to the interpreter. And it was clear from the record, although the jury saw very little of him, that his baseline and his behavior was as far as Dr. Young, who had the greatest opportunity on 2 occasions to evaluate him over days, there was no effect on his behavior appreciably. So even the hope that it would control impulsivity, that didn't happen to any appreciable degree, let alone the underlying issues, because there was no psychotic condition or lack of ability to appreciate wrongfulness or lack of fundamental ability to conform based on a psychosis that was being treated. It wasn't there. The next part of Lorraine, and the reason that the SJC cited for reversing and sending it back, was that Lorraine's demeanor at trial was calm and rational the entire time, and that was a stark and misleading contrast to his psychotic state at the time of the crimes. And so Lorraine, the SJC in Lorraine said the jury was misled, that Lorraine was deprived of an opportunity for the jury to see him in the psychotic state that unquestionably, according to the experts, according to the record, he was in at the time of the crimes. And therefore, in that case, the evidentiary ruling was deemed wrong. He was deprived of meaningful probative evidence. 25 years later, Colleran came up. It's a slightly different posture because it was a claim of ineffective assistance for failure to attempt that, failure to ask for an unmedicated display. But the SJC came out in the same place, I'd suggest, in terms of what the standard is, by distinguishing it from Lorraine. Like the defendant in Colleran, like the defendant here, the defendant in Colleran did not have a diagnosed mental illness or psychosis, but was depressed, had depression, and was prescribed medications at the time of trial not to temper or alleviate psychotic symptoms, but for depression. And the SJC said, 452 Mass at 425, quote, "This is not a case where psychiatric medication deprived a jury the opportunity to observe firsthand disturbing psychotic symptoms reflecting the defendant's mental illness at the time of the crime. And then, therefore, a display of Ms. Colleran unmedicated, quote, would not have been relevant to her defense." Our argument was the same at trial, and essentially it's the basic 403 test. Our argument is that this unmedicated display of Mr. PENA would have had zero probative value for the jury, but even if it did have some slight probative value, it would have been far outweighed by all the other dangers that we identified both in our trial arguments and here on appeal.
It seems so difficult to expect trial judges to be able to make a judgment about, I mean, medical professionals aren't able to do this, but to make a judgment about the effect of a particular psychiatric medication on a defendant's dysregulated state. I see your argument like that the defendant here acted out in very unorthodox, dysregulated ways during trial, but how can we say for sure that this particular medication, if he was taking it and was allowed to present himself without that medication at the time, would not have acted in a substantially far worse way? Or, I mean, it just, these are very difficult judgments that to make in any circumstance, and I'm not sure what legal standard we can apply on appeal, at least, to sort of say whether this was right or wrong.
That's why I would suggest the legal standard goes back to, was it relevant and probative? Our argument is no. If it had any probative value, was that sufficient to outweigh all the risks, the unfair prejudice that could cut both ways, as I hope we articulated in our brief, confusing the jury, unfair prejudice in the sense of misleading the jury, playing into this kind of popular conception that if somebody's on meds, then off meds they must be crazy. It may be unusual to cite the Urban Dictionary in a brief, but the reason I did that was, And another source, there is a popular conception that if somebody has meds, that you take the meds away, then things go haywire. And the only evidence before Judge Campo on this point is that the medication made no difference. In fact, Judge Campo, when he sent Mr. Pena back for the last evaluation on the cusp of trial, he specifically said, I want to hear from Bridgewater about why this medication is prescribed and what's going on and whether he's taking it. And that's when the mental health experts, Dr. Young, there were 5 of them altogether who had pretty much the same things to say about his lack of mental illness, but there were 2 in particular, Young and the nurse practitioner who was qualified to diagnose and prescribe, who said not only was it not prescribed for a mental illness, but it didn't have an effect. It didn't have an effect. So,
sorry, time is running short. I just want to ask you a question. Could you, the issue of competence to stand trial, that was a theme throughout, right? There are many, many, many hearings about competence to stand trial. When did the issue of let the jury see him unmedicated arise, and how was it brought up?
it was brought up during trial.
So the first time it came up was during trial?
I believe. I mean, the record will prove me wrong, but I believe the first motion, there were at least 2 motions to exhibit him unmedicated that were denied. One was denied explicitly. The other was essentially denied by lack of reconsideration. Mm-hmm. The Commonwealth filed oppositions to both. The issue really was brought up and argued during trial, and this was it was perhaps a byproduct of his exclusion from the courtroom, but one important point about that is that the exclusion from the courtroom under Rule 45 to maintain order, that wasn't challenged on appeal. There's no challenge to that. I understand the argument that, his being absent from the courtroom maybe increased a need to show him unmedicated, and in response to that, I come back to the basic argument that it wasn't probative of anything. It wasn't probative of any different mental state.
It seems like one of the issues, it being raised so late, might have been, well, we're going to have to then have a two-week continuance for him to get off the meds, right, or something like that. I mean,
I would say at least 4 or 5 days, because Dr. Young did testify that they took about several days to kick in, generally, but he also said after those several days had passed, he didn't see any difference in the way Mr. Pena was behaving, and I think that alone, I suggest, shows that there wouldn't have been a significant real probative value to showing him unmedicated, and then you add to that the incentive he already had to act up on self-demand.
Okay, your time has expired. But I see no other questions. Thank you very much. I think we understand your argument, both of your arguments. The case is submitted. The next matter we will hear, when everyone is ready, is number 25399. This is Commonwealth versus VASQUEZ. It is partially impounded, so I trust counsel will adhere to whatever the scope of that impoundment order is. We will hear first from Attorney Levin.
Thank you. Good morning. May it please the court, Patrick Levin on behalf of JOCELYN VASQUEZ, who is here this morning with her family. Ms. VASQUEZ's constitutional right to present a complete defense was violated when she was tried and convicted of murder without being permitted to inform the jury that someone else had repeatedly tried to kill the victim of the murder in the months leading up to the crime. The testimony that she would have offered was relevant, percipient testimony. It was highly material to the jury's consideration of this case. It's different in kind from the evidence at issue in the cases relied on by the judge, which excluded speculative testimony that just because someone was involved in an illegal enterprise, someone else may have wanted to kill him. In this case, the evidence was that someone actually had attempted to kill the victim. The judge appeared to recognize the materiality of this evidence during the trial. You notice at page 87 of volume 11, he says, you know, this is information that is not admissible and it's going to the heart of what this case is being tried on. But in his order on the motion for a new trial, the judge ultimately says that the evidence is not admissible. And he did that by applying the wrong legal standard, essentially. The question is whether the evidence was relevant. It was. It was admissible, relevant testimony, and she should have been able to present it. Now, the Commonwealth, primarily on appeal, attempts to justify the judge's order as a discovery sanction. Notably, the judge did not attempt to justify his order on this basis on the motion for a new trial, although this was the primary ground that he relied on during the trial. Now, there's two pieces to this question of whether the order can be justified as a discovery sanction. First is whether there was a discovery violation in the first place, and then secondly, whether the judge made the necessary findings to permit preclusion of vital testimony as a sanction for any violation that occurred. First, there was no discovery violation that justified the imposition of a sanction here. A defendant is not required by any positive rule of law to disclose her theory of defense, except with 4 specific exceptions enumerated in Rule 14. Defenses of alibi, mental health, license or authority, or an adjutant self-defense issue. Those are the only required disclosures of a theory of defense. Now, the judge made an order on a reciprocal discovery motion that would have had to be the basis of any requirement that the defense attorneys disclose the evidence at issue here. Notably, the order specifically required her to turn over only statements of witnesses to be offered either by the defendant, you know, statements of witnesses for either party, as required by Rule 14 and by Commonwealth versus Durham, and any intended exhibits. The judge's written order on the discovery motion did not expressly require the disclosure of what the Commonwealth termed in its motion prior bad acts of the victim. As the prosecutor recognized during the colloquy on the first day of trial, the judge did not appear to understand the requirements of Rule 14, and as a result, he was under a misimpression about what he, in fact, had ordered. He believed that statements of witnesses means what it is those witnesses are going to testify to. That's not what it means. Rule 14D has a specific definition of statements, and it's only statements that are written down, you know, either written by the witness or adopted by the witness, or recordings or substantially verbatim transcriptions of a witness's oral declarations. The only situation in which a party is required by Rule 14 to give notice of the content of oral declarations that have not been reduced to writing is for statements of a defendant or a co-defendant. The judge clearly does not understand.
Sorry, Attorney Levin, I wanted to direct you actually back to something. The Commonwealth describes the third-party culprit evidence in basically 2 packages, 2 bundles. There's sort of the prior attempts to kill him because of counterfeiting, and then the T stuff.
Yes.
Right? So the first bunch, and that was what offered by the victim's brother.
That's right.
So that may be the established motive, but I'm reading out of the guide to evidence here. Evidence of a third party's ill will or possible motive to commit the charged crime standing alone is insufficient to qualify as third-party culprit. The evidence must also show that the alleged third-party culprit had the intent and opportunity. So what was there that, I mean, I understand your argument about the significant links that doesn't apply here because we're talking about non-hearsay. But there has to be some link that puts them near the scene of the crime, doesn't there?
No, Your Honor, that's not right. The cases about other similar crimes, this is the line of cases that goes from Murphy through Keyser to Jewett, and Jewett cites to Bueno, which is a Colorado case that I also cite in the brief. These cases make clear that regardless of whether there's first any identification of the perpetrator of the other crimes, or second, any express connection between those other crimes and the crime on trial in terms of evidence that the person was actually at the scene of the crime. That evidence of other crimes is admissible if it's relevant, if it goes to show that someone else may have committed the offense. And in those cases,
I mean, how does it? Just the fact that somebody disliked him. How does that mean that they were there on the back steps when your client was going out the front?
So, Your Honor, it's not just evidence that someone disliked him. It's evidence that someone repeatedly tried to kill him.
Okay, they hated him and they wanted to kill him. But
It's
again,
not just
how do you?
evidence of motive. It's evidence of intent.
But again, you still. How do you link it to this particular killing, to this particular murder?
The link is that they repeatedly tried to kill this particular person and failed to do so, but it doesn't take speculation to infer that someone who repeatedly tries to commit a particular murder of a particular person may keep trying until they succeed. And then there's a second link, which is that at least two of these prior offenses occurred during these counterfeit currency transactions. That's what, Victor testifies. I was driving him to these transactions, and during these transactions, he comes, I hear the gunshots, he comes running back to the car yelling, "Somebody's shooting at me." And then Ms. Vasquez's testimony, or her proffer, was that just before he died, he told her that he was on his way to a counterfeit currency transaction where, he was, so if, you have to understand how all of the evidence fits together.
And what I think, I'm not sure if I'm asking the same question as Justice Massing. I see how there's evidence of intent. Someone wants to kill him, has tried more than once, maybe, or maybe more people want to kill him, I don't know, but let's say there's evidence that would support a finding that they tried more than once. There's no reason to think they don't want to still kill him. There's someone out there with the intent to kill him. What about opportunity? I mean, I think that's what Justice Massing is focused
Your Honor,
on.
there is no case that holds that third-party culprit evidence cannot be offered without specific evidence of opportunity.
Okay.
The language that the judge points to, it doesn't say third-party culprit evidence is admissible if you can show someone else had the intent, motive, and opportunity to commit the crime. It says evidence is admissible if it has a tendency to show that someone besides the defendant may have committed the crime or had the intent, motive, and opportunity to do so. This evidence shows that someone else may have committed this crime, not the defendant on trial. And it's just the same as these cases, Murphy, Keyser, Jewett. These cases, there is no evidence of who the perpetrator of those other crimes were. There's no way to show that that unidentified person had the opportunity to commit the crime on trial. There is evidence that those other crimes are similar enough to the crime on trial that it's reasonable for the jury to have a reasonable doubt based on that evidence. And it's worth keeping in mind that's all that is required here. This is not an affirmative defense.
You don't sort of see any kind of limitation on the extent to which a defendant can raise a third-party culprit theory, right? I mean, the judge did seem to sort of say it's got to be tendency to prove that another person had the motive and intent and opportunity to do so. And you're saying those things are not factors.
They can be factors.
They can be factors, yes, but but they don't have to be. So is there any, does the judge have any discretion to sort of say that's not persuasive, I don't think that's a viable theory? I mean, what are the limits? What discretion does a judge have to sort of say that doesn't come to the level of what can be presented?
So the limitation depends on whether the evidence that's being offered is otherwise admissible. If it's not otherwise admissible, then you have to meet this substantial connecting links requirement, because the right to present this defense is so important that we cannot just exclude it based on the normal rules of evidence. If the evidence is otherwise admissible, then the limitation is relevancy. This is what Conkey and Jewett, these cases are very clear. You can't exclude admissible evidence that's offered by the defendant that's relevant to the crime without some positive rule of law that justifies the exclusion. If it is so attenuated, so speculative, that the jury would have to actually speculate in order to connect it to the crime, that's one thing. And the cases are clear. In that case, it's not admissible. That's Acevedo. This guy's a drug dealer, so who knows who killed him. That requires speculation. This doesn't require speculation. It shows that there was a credible, active threat on this man's life around the time that he actually was killed, based on a motive that had no connection to Ms. Vasquez. Moving back to the discovery sanction, unless there are more questions about this, the judge did not make, so there's 5 factors that the judge is required to make express findings on. He did not make express findings on at least 2 of the factors, and he didn't make sufficient findings, I would say, on 4 of them. To the extent that he makes a finding of bad faith, that's infected by his misunderstanding of what statements means. And you can see that in the transcript. He says, you didn't turn over statements, that's, you didn't comply. He doesn't make a finding on prejudice to the Commonwealth independent of the finding on surprise. And the finding on surprise is well supported. To be clear, the better practice would have been to have raised this in a motion in limine. But it's not a required practice unless there is...
To raise it as, so we want to present this evidence.
Right.
I mean, clearly the colloquy, I take your point that of what Rule 14D does and does not require, and you have a position there. It clearly seems at the time that the judge believed that the defense needed to provide information about what these witnesses were going to testify, and the Commonwealth is very clear. We have they're not in our investigation. We have no idea why they're being called, and so there was at least an expectation by the judge that,
I think that's
that
right.
the defendant should have disclosed.
I think that's right, but the expectation, A, is based on a misunderstanding of what statements means under the rule. But B, insofar as we're resting a finding of bad faith on it, that back and forth on the first day of trial really undercuts that finding, because they say, well, he says, I didn't actually order you to reduce anything else to writing. And they say, oh, we really misunderstood your order then. In that case, our position is still we should only have to turn over what's required by the rule. And at the end of the colloquy, he says, well, look, I'm not going to require you to turn anything over right now. You just have to be aware that if it turns out that it's something you should have turned over, that it might not be admissible. But when he says that, he specifically references adjutant evidence. And so counsel reasonably thinks he's talking about something that should have been turned over under the Rule 14 mandatory discovery rules. To the extent the judge considered the materiality of this evidence, he considered it backwards. He appeared to believe that it weighed in favor of preclusion, but it actually weighs against preclusion. The more material the evidence is, the more important it is for the jury to hear it and to vindicate the defendant's constitutional right to present a defense. That's clear in Durning and Steinmeier. And there's
this reference to, in Sylvia Santiago, to the admission of feeble third-party culprit evidence. What do you understand that to mean? Do you just mean relevant or not relevant, or is there some other kind of gradient that we need?
So there's that's in the context of the discussion about hearsay and substantial connecting links. So, if the evidence is hearsay and it's totally unreliable, that it's proper for the judge to exclude it in that case.
Can you answer? Quick question on the hearsay. How does the statement about, your client's statement about the victim going to meet T, how does that come in?
That's a statement of present intention.
And so could you expand on that just a little?
So a statement...
I'm going to ask Attorney Hartley why it isn't. So tell me why it is.
Well, because he's saying, I'm on my way right now to go meet this person and engage in this conduct. And so that
proves that he did go meet the person?
It's admissible to show that the intention was in fact put into effect. And Commonwealth versus Britt and Commonwealth versus Ortiz, I cite in the reply brief, apply this rule to statements of murder victims about where they're going and who they're on the way to meet right before they're killed. It's very on point. I see that my time has expired. I was hoping to address the lost evidence issue, but of course...
I think we have your argument on that. Thank you very much. If there are no further questions, very helpful.
Thank you, Your Honor.
We will hear next from Attorney Hartley.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth, and with me at council table is the trial prosecutor, First Assistant Edmund Zabin. This court should affirm the denial of the defendant's motion for new trial and affirm her convictions. I'd like to start first with the discovery issue. This case is exactly what Durham warns against. It was trial by ambush. And I think that's important context for all of the issues on appeal. It's relevant to every issue raised, really. And I think a failure to address this discovery issue by this court would condone what was really gamesmanship at this trial, and in doing so also limit the power of trial judges to make really important evidentiary rulings. And I disagree with my brother about whether the judge misunderstood what he was ordering and the discovery order in general. So the Commonwealth filed this written motion for reciprocal discovery, asking under number 6, page 55 of the record appendix, specifically for prior bad acts of victim or witnesses. The court's ruling, although it didn't specifically address the prior bad acts, was that the defendant must produce the requested discovery. The ruling was clear, but not only was it clear, it was repeatedly clarified throughout trial. For example, this happened repeatedly, but if you look at transcript volume 11, 17, 18, the judge says, I note the Commonwealth's objection all along to anything that deals with prior bad acts with the victim in this case, and certainly the rule is that that doesn't come in.
So I'm in trouble with understanding how for example, the testimony that other people wanted to kill the victim, how are those prior bad acts?
So I think all of the testimony from Cardona related to the defendant being involved in this counterfeiting operation, which from the Commonwealth's presentation of the evidence was really not much of an operation. It was described as an unsophisticated operation where I think about between $400 and $500 of counterfeit money were found in his apartment. But because it relates to the counterfeiting scheme, he's going to the two that I think defendant is relying on most is he was participating in this exchange of counterfeit money and then shots were fired at him. One of the prior bad acts is actually him pulling out a gun on an individual who comes to his back door. They allegedly get into an argument over money owed. The victim pulls out a gun and this individual leaves. So I think they all would qualify as prior bad acts.
That's a prior bad act, pulling out a gun in a transaction with someone else. I mean, it does seem like there's a conceptual gap between the prior bad acts focus and the evidence that they're pointing to of other people who had motivation to attack the victim, right? There seems something of a gap there that I'm trying to...
Well, I think pulling out a gun, the jury hearing that the defendant pulled out a gun during an argument is absolutely a prior bad act that should have been vetted.
The victim.
I'm sorry, the victim pulling out. It was absolutely a prior bad act that should have been vetted beforehand. And the judge should have had the opportunity to determine whether that was admissible evidence or not. And I would also just note that this is discretionary discovery under Rule 14(d)(2)(d), which allows the judge the discretion to order additional discovery upon motion of the Commonwealth, so long as it doesn't violate the defendant's constitutional rights. And obviously, reciprocal discovery from the defendant is going to be narrower.
So you didn't ask for, or you weren't, she wasn't ordered to turn over a statement. Well, it's not a statement. The fact that a witness would testify someone else shot at the victim previously. That's not the victim's past bad act, right? And it's not a statement because it's not under the definition on 14b, it's not a written or oral statement, right? So you didn't request that.
I disagree with the first part. I agree that it's a statement. I disagree that it wouldn't constitute a prior bad act.
Of the victim?
Yes, the victim.
Being shot at?
Being involved in this counterfeiting operation where he's
I didn't ask about that. I asked about the testimony that he was shot at.
But that is in the context of him.
Let's say the person had just come in and testified. I was with him in a car. Someone shot at him.
Well, there is a piece of evidence like that. I think all of those things would constitute prior bad acts because it shows that the victim is involved in these violent
shot at is a prior bad act of the victim?
In this context, yes. In some contexts, maybe no.
All right, so I want to also press on the prior bad acts piece of this. And frankly, on the state. So you agree, we're not talking about statements
Not
that
talking
have to
about
be turned
reducing
over.
statements to writing. It was
Okay.
to make a proffer about prior bad acts.
I'm now going to read what the order says.
Sure.
Not what the motion says. After taking the matter under advisement and reviewing the cited case law as well as Rule 14 and accompanying reporter's notes, it is the court's conclusion that VASQUEZ must provide the requested reciprocal discovery. That's the phrase that you are relying on. But then, for 2 paragraphs, the judge goes on and describes what has to be turned over. VASQUEZ must now disclose the information regarding statements of the persons she intends to call as witnesses at trial and all intended exhibits. The discovery of this information is required under Mass. R. Crim P. 14A1B, which provides for automatic reciprocal discovery for the prosecution. The defendant must also produce all statements of witnesses for the Commonwealth, including statements that the defense intends to use for purposes of cross-examination of the prosecution's witnesses. That's it.
I understand that the order specifically addresses statements.
I mean, if I were a lawyer trying to comply with this order, I would do what I was ordered to do. I wouldn't go back and look at your motion and see if you asked for some other things. The order specifies he must do this, he must also do this.
Well, it may be confusing in isolation, Your Honor, but I think if you look at, this was litigated before trial. There is a record where counsel goes back and forth with the Commonwealth and with the judge about what we're talking about here. And I think it is very evident in the record that these prior bad acts the judge was requiring them to be turned over, and it's also
Well, if the judge had written that in the order, then they would have to be turned over. But what was argued, I mean, sometimes people come in here and say, but the judge said he believed X. But if the written order says, I don't believe X.
But it doesn't say I don't believe X.
No,
Your Honor.
All right, it says some things and not the prior bad acts.
So I understand, I hear your point, and perhaps the judge could have used clearer language, but I do think it is relevant that what happened before here. So when the parties came in at the final pretrial conference and the Commonwealth expressed a concern that we have this witness list and we don't know how these witnesses are relevant, that's why we're filing this
All
reciprocal
right, and
discovery
your position is the reason that that the defendant was barred, could lawfully be barred from bringing in this third-party culprit evidence, the testimony of this witness, was because it was a discovery sanction. That's
one reason.
Well,
and-
let's
yes.
start with that one. Is complete elimination of the evidence coming in an appropriate sanction for following the specifics and not going back and looking at the motion because of this initial sentence?
In this
That's
context,
a pretty hardcore sanction.
In this context, I think yes. I think also when you look at how this was litigated, and I understand Your Honor's point about the order, but counsel implied on the record that the only evidence of prior bad acts related to this counterfeiting money. The court and the Commonwealth were intentionally misled.
Okay, but you weren't misled that he was a counterfeiter.
No, the evidence.
You guys knew he was a counterfeiter,
the
right?
evidence presented by the Commonwealth was that there was counterfeiting between $400 and $500 of counterfeiting money found in the apartment, and the evidence was also that this could be equally attributed to the defendant and the victim. The evidence was that this defendant appeared to be living with the victim, and the Commonwealth expressed to the court that, if we're going to get into this puts us in a difficult position.
Okay, but the important evidence here isn't the counterfeiting. The important evidence is somebody else shot at the person. I'm not saying the jury had to believe that. I understand who the witness is. I don't, you know what I mean? I get all of the credibility things that you could have said to try to undermine that evidence. But that's the evidence. And I just don't see that it was ordered to be turned over. I mean, you say it's a past bad act of the person. It's a past bad act of someone else. It may have been caused by a bad act, counterfeiting. Right?
Well, I think the defendant's argument would be much different if this were just shots fired at the defendant. I think the defendant is relying heavily on the fact, weaving this counterfeiting theme throughout.
Would you say you were ambushed if he had brought someone in who just testified, when I was with the defendant, the victim, twice he was shot at? I think it's twice.
Well, I think in this context, when the
But that, you wouldn't have known about that, but that, if that was the whole testimony,
well, I think saying that in isolation, saying that someone shot at a defendant unrelated to what the defendant is alleging is this large-scale counterfeiting scheme would be an entirely different question.
it would be harder to explain, but it wouldn't be an entirely different question. It would mean that someone wanted to kill him who probably wasn't the defendant.
And to be clear, I think that would not come in under a third-party culprit. So even if the discovery order.
Why not? Yeah, that's the
Yeah,
next piece.
sure. So I can address third-party culprit and then jump back to whether exclusion was the proper remedy, if Your Honor would like.
Well, I want to know, let's assume for a minute that exclusion was wrong as a discovery sanction.
Yes.
You still say it can't come in.
Correct.
And that's because,
That's because this was inadmissible under third-party culprit doctrine.
Okay.
Because the evidence was entirely speculative and it did not tend to show that another person committed this crime. And compounding the problem, I know that the defendant disagrees that this is part of the determination under third-party culprit doctrine, but compounding the problem is that all of this proffered testimony derives almost entirely from witnesses aligned with the defense and self-serving sources.
and I suppose all of your testimony came from witnesses aligned with the prosecution. I mean, that's.
Well, not necessarily. I think.
Right, I mean, we don't discredit things because they come from.
No, but I think it goes to the Commonwealth's point that this was trial by ambush and that the judge, as a gatekeeper, not only, when determining whether evidence is third-party culprit evidence and looking at relevancy, looking at opportunity, motive, and
But you
intent.
don't usually know the defense, right? The defendant doesn't have to reveal her defense until trial. Basically,
to some
subject to
extent.
these, subject to the constraints of 14B, and if there were discovery order.
To some extent, but I think there's a line, and I think it was crossed in this case. If you look at Durham says we have upheld reciprocal discovery of obligations despite their tendency to compel defense counsel to make strategic decisions before trial. And Durham also says that a defendant's right to defend should not be taken to the point.
No, but I'm saying let's assume there was no discovery violation. I'm not, I haven't decided that, and we
Okay.
certainly haven't even talked about it, but I'm just asking, if you assume it's not discovery, it's just evidence.
Sure.
It's not that's about a reciprocal discovery order.
It is, but I do think that the context and what the Commonwealth is alleging was trial by ambush is relevant to the judge's ruling. And I think defense counsel disagrees and says that credibility has nothing to do with it. I think that the judge is a gatekeeper here and has a responsibility not only to weigh whether the evidence tended to show intent, motive, and opportunity, but to look at this alleged third-party culprit evidence and as the gatekeeper determine whether the jury should hear it. Third-party culprit, as the defendant proffers it, would mean that anyone could come in, make up any third-party culprit, and that would be relevant simply because.
Well, anyone
it's
can
third-party
come in,
culprit.
and they're under oath, they're not supposed to, but they can come in and they can make up that they saw someone else do the shooting. They can come in and make up that they were in New Jersey with the defendant at the time, right? I mean, of
And
course.
the Commonwealth's position is that the judge, as a gatekeeper, should and did vet that evidence and has the power to say, well, this doesn't come in not only because it's.
I thought cross-examination was the way that we proved that evidence was not credible. I didn't know that the judge
Absolutely.
got to leave out recipient witness testimony.
I think that absolutely cross-examination is how we determine whether evidence is credible. But the judge, as the gatekeeper, has the ability to look at evidence and say this is uncorroborated, unvetted, sprung on the
It
Commonwealth
doesn't
at
have
the
to be
last minute.
corroborated, it's a recipient witness.
It doesn't have to be corroborated, but I think it's all important context to the ruling.
Can I just trying to understand the setting aside trial by ambush and all those points? The judge said in the motion for a new trial that the evidence wasn't admissible because at most it suggested that the victim made violent enemies from passing counterfeit money to drug dealers and others. And he seemed to say, wow, there wasn't enough to allow the jury to identify an alternate perpetrator. Is that really, you really have to have that level of specificity? I mean, it seems relevant to me that there are other people trying to harm the victim. Why isn't that enough to go in, particularly since under Silva Santiago, Santiago, we say the SJC said all doubts should be resolved in favor of admissibility. So I'm just trying to understand, like, what's the principle here that you have to actually have a specific person in mind?
Oh, so I don't think there has to be a specific person in mind, but there has to be more than what we have here. So here we have 3 pieces of evidence. Well, we have Victor Cardona's testimony, and I see that I'm out of time. Is it?
Yes, but you can answer questions.
We have
from the
Victor
panel.
Cardona's testimony that the victim was observed arguing with this man. Victim pulled out a gun. And that was 3 weeks before the victim's death. And then we have the observed unknown person shoot at the victim during 2 different counterfeiting transactions, which was approximately 1 to 3, we don't have a precise date or time, 1 to 3 months before the murder, which may show an intent to kill at that time, but doesn't show opportunity and doesn't show an intent to kill on the day that the victim was actually killed. Then you have the sitting in the car with the victim parked in front of his apartment, where this person drives by and shots are fired. This piece of proffered evidence is so obscure that it's really not even clear that the defendant was the target. And it's described as happening in the weeks leading up to the murder.
So you seem to say you have to have, like, intent, opportunity on the day and time and day which the offense actually occurred, right? They're actually, I mean, it seems like, I just don't know where that comes from.
So I think Conkey is a case that the defendant cites, and I think that's helpful to the Commonwealth here. There's the relevant evidence is that the victim was strangled in her apartment with a nylon stocking and her clothes was ripped off. There's 2 trials here. So the court found in the second trial that the evidence was improperly excluded, and that evidence was that there were 5 instances where a potential third-party culprit, the landlord, had sexual aggression towards women, including a rape allegation that was 7 years old. And there was evidence of women's lingerie in his apartment and sexually explicit photos of former girlfriends. So the court said that when you combine that evidence, that the landlord had access to the apartment, he had a key, and he lived right down the road, that's enough. But when you look at what happened at the first trial, I think it's very telling, and it's very instructive to this court here. At the first trial, there was no error in the refusal to admit evidence of the 7-year-old sexual assault because the court said that the points of similarity between the present case and the crime committed by the victim's landlord are few. And indeed said that even though there were nylons found in the landlord's residence, there was no connection between those nylons and the nylons that were used to strangle the victim. So
Let
the
me
reason.
pause you there.
Good, thank you.
Is that, I mean,
Yes.
more
Just one
questions?
more?
Yeah, of course.
Why isn't the statement, "I'm going to meet T," admissible as a present?
So I understand defense counsel's point, and I think that it could be, perhaps is not hearsay. However, I don't think it matters, because I still think you have to have the motive, intent, and opportunity. You don't have to have the substantial connecting links, but you do have to have much more than what we have here.
Thank you.
Thank you very much. Also,
Thank you,
very
Your
helpful
Honors.
argument. The case is submitted. The next matter we will hear is number 25-1211. This is Commonwealth versus Johnson, and again, it's partially impounded. I should just alert everyone, at the end of this argument, we will take our traditional mid-morning break, so we'll leave the bench for 10 to 15 minutes before coming back and hearing the final 2 cases. So with that, we will hear now from Attorney Moorer.
May it please the Court, Ann Maurer for Mr. Johnson. The Superior Court abused its discretion below by finding that trial counsel was effective when, by his own admission, he could not find a cohesive narrative to support his chosen defense that the kids were lying. And had he consulted with an expert, it would have allowed him to assume the lesser burden of showing that either instead of the fact that the kids were lying or in the alternative, that their wildly inconsistent testimony was the result of false memories induced by social pressure. The court below also erred in finding that trial counsel's failure to consult with an expert was a strategic decision, when in fact it was no decision at all. The court's decision below addresses other choices that were made through the course of the trial and essentially concludes that because counsel made other strategic decisions, this too must have been a strategic decision without actually addressing trial counsel's failure to consult with an expert and the reasons why. And then finally, the evidence of prejudice is strong in this case. We have what was probably a 20-minute summation by the prosecutor in which she relies on Dr. Block as the backbone of her argument. She mentions her 9 times in her summation to bolster every single inconsistency that the child witnesses came up. In particular, using Dr. Block's misleading testimony about trauma-induced or trauma-formed memories to suggest that any inconsistency is because the child is remembering a peripheral detail instead of the central detail that we might expect them to remember. And we also know that this jury discredited much of what the children testified to. Out of the 12 counts that were submitted for their decision, they acquitted on 5 counts, including 3 counts of rape of a child. So they had serious concerns with the credibility of the witnesses in this case. And for those reasons, had counsel consulted with an expert, we can expect there would have been a different outcome.
You make some good points that we'll ask the Commonwealth about. In my perspective, the biggest problem with your position seems to be trial counsel's acknowledgement that it would have been a, quote, hard sell to the jury that, quote, 2 different individuals developed the same or substantially the same false memory simultaneously, right? So that, if it were just one victim here testifying, but when you have 2 different victims telling stories that kind of align, how do you deal with that when it comes to the prejudice analysis?
I think that testimony by trial counsel is evidence of his failure to understand what social influence can do. We're talking about 2 7-year-olds at the time of the offense. There was testimony that the 2 boys told their mothers, or there was a conversation at the time of RJ's disclosure, which was in 2017. DW doesn't come forward to the police until 2019, but that in 2017 there was a conversation with the 2 mothers and the boys. And these are families that
All 4 of them?
That was DW's testimony, yes. RJ rejected that, but that was evidence at trial.
They lived in 2 different towns by now, or just?
At that time, I'm not sure where DW was
I thought at
living.
the end of the school year when this happened is when they moved, but I may be misremembering.
It's a false memory.
Many of mine, I guess, are then. I don't know.
The mothers were friends, and you know, from the record,
But not in contact.
according to several witnesses,
Okay.
yes.
I mean, I'm just trying to figure out, because I had the same question that Justice Toone has, which is you have to show that there was prejudice, and I'm not sure why 2 different people having false memories of something when they aren't in the same environment during the ensuing time is a better defense than one of them's making it up and the other one's backing him up.
Well, I don't think it's a far cry to ask the jury to assume that 2 preteen boys are still in touch with each other when they no longer live in the same town.
And are constantly talking about this event to the point where, I mean, I just don't know that you have any evidence of that. I mean, there could have been some, I guess.
But even one conversation could have planted the seed of a false memory in these boys. And the trial counsel could have argued in the alternative. Look, maybe RJ's lying and DW has this false memory. There were multiple options that he could have pursued to present to a jury that had real concerns about the credibility of these witnesses. And it's clear that the stories they told the jury cannot both be true. They're diametrically inconsistent with each other. And Dr. Block's testimony cannot explain away those types of inconsistencies. It may be true that they would remember different details, but you're not going to be able to explain away DW's testimony that he only engaged in sexual contact with RJ, and RJ's testimony that he saw my client have sexual contact with DW. They're just not consistent.
Was he convicted of the sexual contact with DW? I thought he was only convicted of the things where the two of them agreed. I may be mistaken again.
That may be correct, Judge.
Okay.
Let me ask you this. Dr. Price's affidavit says that she was contacted to provide an opinion about the missed opportunities in cross-examination. That's great in hindsight, but we have to look at it from the position of defense counsel at the time of trial. He learns that Dr. Block's going to be testifying. Does every defense counsel have to ask if the Commonwealth has a repressed memory or a delayed disclosure expert? If he asked for funds, what would the motion for funds say?
Well, it would likely mimic what the Commonwealth's motion to admit the testimony of Dr. Block said. So in this case, it was about delayed disclosure, and also I think the characteristics of child victims of sexual assault.
So he wouldn't have asked for, what would have ever prompted him to ask for a false memory expert?
False memories are a common type of disclosure. Well, it's a common area of testimony for experts such as Dr. Black or anyone who is an expert in.
So does the reasonably fallible counsel know that?
Every trial counsel trying sex assault cases should know that, and I believe does know that.
This was his first sexual assault trial, though, right?
That just is all the more reason why he should have consulted with an expert.
So I mean, I need an expert just in case.
Yes.
So I mean, so it's ineffective. It's ineffective not to ask if the Commonwealth has an expert, not to ask for an expert.
When he is assigned a case with sexual assault allegations by 7-year-olds, and there are video interviews with the children, there are multiple video interviews with one of the children, it is ineffective not to consult with an expert about, hey, what in this file can I use to that might be helpful to attacking the credibility of these witnesses against my client.
Okay.
And I would just add that in this case, this was not a case where Dr. Block was just testifying about delayed disclosure. It was not even clear that that was going to be part of the Commonwealth's arguments because of the time differences in the two children's disclosures. But timing was an issue. There were multiple interviews with at least one of the witnesses, and there was this whole situation where the boys' testimony was incompatible with each other. And so this case is not a standard delayed disclosure case that maybe counsel might have thought, oh, I know what that is, and I'm not worried about that. This was a different kind of case.
So what's the difference between Dr. Block did talk about social influences, right?
No. Dr. Block admitted that children have been known to lie. I think trial counsel asked her once, do children ever lie? She admitted yes. But she didn't testify as to the various ways in which false testimony can come out, which include lying, yes, of course, but also include false memories, social influence, and all the various ways that Dr. Price testified to.
Right. She didn't talk about false memories at all, right?
Correct.
These were all. I think, and defense counsel did try to get at, how do you know that any of this is true? How do you know that people aren't right? Wasn't there a line of questioning about that?
Trial counsel's focus was on Dr. Block's relationship to the prosecution and her research, and he did not try to attack the substance of her testimony. Are there any further questions?
I don't see any.
Then I would just ask this court to reverse the court below and remand for a new trial.
Thank you very much. We will hear next from whom? Attorney Shepard Brick.
May it please the Court, David Shepard Brick on behalf of the Commonwealth. The difficult hurdle, I think, for the defendant here is that the only defense that could possibly have been raised with the use of Dr. Price's testimony that wasn't substantially covered in Dr. Block's testimony is the testimony regarding false memories. And counsel said, yes, I'm aware of the phenomenon, and I rejected it for strategic reasons. I think it was a hard sell. So I don't, as the motion judge did below, looks like you have a question.
No, go ahead. I'm teeing up, but keep going.
The motion judge below found that it was not manifestly unreasonable. So she didn't even get to the prejudice analysis because he's allowed to make that tactical call. He is allowed to say, even compatible defenses, you don't have to run them all. That was my sister suggested, well, he could have argued both. Yeah, he could have argued both, but there's ample case law where.
Well, he says he was familiar with it.
Yes.
He went to his mentor.
Correct.
And apparently, from what everyone says, very experienced attorney.
Extremely experienced.
And
you probably don't see a lot of his cases because there are a lot of not guilties.
So, he goes to this person. This person has seen the Commonwealth's expert before.
Yep.
Even has a transcript that shows what her testimony looks like, or maybe a report. I don't know, something.
It was a transcript of a prior cross-examination.
But none of that tells him, frankly, what false memory is. I gather it's something different from social pressure.
Well, so
right?
And
I guess the argument, I certainly agree, two people having literally false memories of the same thing, unless they were, right with each other in the months and years following or whatever.
Right.
I don't know when these memories form. It has something to do with delay, though, so, right, I gather, because, I also have to say, he says it's not a delayed disclosure case, but of course it is. So, that's a little problematic, too. So, but in any event, mightn't the best argument, now maybe the best argument is social pressure, which he glancingly referenced, might get the first kid to say this, and the other kid is backing him up, knowingly backing him up.
Right.
And isn't going to say this happened or that happened or whatever, but is willing to say this, whatever it is. Maybe it would have been better if he'd said it was a false memory that the first kid had, that he was being backed up on. That is, two kids lying isn't a great defense either. Obviously things happen, right?
There are no great defenses in this case, and I think that's what counsel was stuck with.
Well,
you have inconsistencies, and the jury clearly rejected all of the inconsistencies. As Your Honor pointed out earlier, the convictions were on the instances where both boys agreed as to what happened. There was a slight difference. The rape counts regarding simultaneous oral sex between the boys. One testified it was simultaneous, the other testified it was not. There were convictions on both of those. But the sexual assaults that just took place on RJ
well,
without
doesn't that
corroboration.
suggest with a little more work, maybe, he could have converted that obvious concern that there's something not credible somewhere in here into, so don't even believe the stuff where they say the same thing, right? Because now you know that there's something not credible going on. They acquitted both of the... Did they acquit the defendant of, well, I guess the kid testified it didn't.
They convicted the defendant of the sex crimes that both boys testified to. They also convicted him of the assault and battery dangerous weapon charge, which only RJ testified to. So they did find his testimony on that instance credible. To your Honor's question, maybe it would have been better, maybe it wouldn't have been, but that's a strategic call. So whether we're at the first prong
But
or the
if he
second
doesn't really understand what false memory is, how can he make a strategic call?
Well, so Dr. Price's testimony about false memory, actually, it's interesting because what she testified to was that false memory, that social influence has two different paths. It's social influence that creates a false memory, or social influence where the child is just lying. So you really have, she says there are three different ways, but one of the ways in which a child lies is, which is a straight out lie, is actually assumed within two of her different ways. So the only thing that she offers is these false memories by social influence. Deliberate lying by social influence was covered. Not only was it covered in his closing, 5 deliberating jurors suggested in voir dire that a child could lie because of social influence, because of a family member. One of them even said, oh yeah, because of a custody dispute. So,
Well, that may be how you wind up with acquittals on all of the charges that are just based on RJ's own statements.
well, except the assault and battery dangerous.
No, I understand the sexual.
Was there a specific voir dire question that elicited those answers from the 5 jurors?
Yes, so defense counsel was asking every prospective juror, do you believe that children always tell the truth, or do you think that there are some instances, and I'm paraphrasing, there are some instances where a child might lie? There were, I want to say, 3 jurors that were excluded. I think 2 jurors were excluded for cause, and defense counsel used a peremptory challenge based on the juror's answer to that question. All of the jurors who were seated said they wouldn't automatically believe a child, and as I said, 5 of the deliberating jurors specifically mentioned social influence as a reason that a child might lie about sexual assault.
So that it was attorney voir dire.
Yes, this was an attorney.
So he is laying the lying theory at the very beginning.
Correct. Right. This was his theory from the beginning. He consulted with an extremely experienced defense attorney who had cross-examined this expert before, who had done many, whether you look at it as first prong as the motion judge did, was it manifestly unreasonable? The question isn't whether this court would have, in hindsight, made a different judgment call. The question is it completely out of the realm of reasonableness? And then, even if you get to the prejudice prong, it's essentially, as the court said in Millian, it's substantial risk. This court has to have a serious doubt as to whether the defendant's guilt was fairly adjudicated based if you find that counsel erred. So you have to basically, not just maybe this was a better defense or maybe this was a better defense, you have to say, look, we have a serious...
One problem I have with your argument is that, and you argue that it was a reasonable strategic decision for defense counsel to focus on, that the victims were lying, right? But it doesn't seem like having an adversarial presentation on the issue of memory was inconsistent with that position, right? It's not like it was one or the other. Having someone cabin the scope of Dr. Block's testimony would have set back the strategic decision that the defense lawyer was making, right? I just don't see, they're not mutually exclusive.
They're not, although, again, as the motion judge found, Dr. Price's testimony wasn't significantly different.
Well, on that, I got a different question. So on the issue of traumatic memory, right? The judge wrote that Dr. Block's testimony does not differ significantly from Price's affidavit, wherein she states that sometimes stress will enhance memory and sometimes stress will impair memory, correct?
Yes.
But Block's testimony was not 50-50, right? She testified that when an event is traumatic, individuals may remember central details better than peripheral details, right?
What-
And
well,
Price's
so-
position was that, well, sometimes traumatic memory is enhanced, sometimes traumatic memory is impaired. That's a different perspective than what they got from Dr. Block's testimony.
So what Dr. Block said is that there are studies about traumatic memory that show that people focus on, central details and not peripheral details, but what is central to them is not necessarily central to another. So she didn't say that traumatic memory was better. She simply related that there are studies about traumatic memory.
It seems like there are some different perspectives that could have been offered here, and I guess it goes to my underlying question of why do we have experts on memory to begin with, right? Isn't this something that's essentially within the a jury's common knowledge? And having one person go on the stand and say, well, memory works this way, this way, this way, seems like that's generally something that the other side should have an expert as well to sort of present countering perspectives.
If you really are going to have an expert who presents a really strong counter perspective, based on her testimony, Dr. Price's testimony at the motion for new trial, the motion judge said, to me, it seems like her criticisms of Dr. Block don't hold up. That her testimony, she said, Dr. Price says, well, people focus on central details and ignore peripheral details in non-traumatic situations. But then she goes on to say, but also children don't necessarily experience sexual assault as traumatic. So that's a complete wash. It's the same, you get the same impression from her, okay, well, maybe it's not a traumatic event, yet still the child is going to focus on central details versus peripheral details.
It seems like they were saying different things, but it may not rise to the level of and I think there's a prejudice problem with the two different victim testimonies. But I find it generally concerning when there's a one-sided presentation from an expert on memory issues, and I understand that Dr. Block's been around the block and presents this testimony in a way that's kind of consistent with court guidance, but it does seem like in many circumstances it would be a good idea for a defendant to put on a counter expert, even if that's not the main thrust of his defense.
Well, and that's where I get back to one, it's a strategic decision, and so it has to be manifestly unreasonable. This is not a case where, Million of this is the shaken baby case, where the defense attorney doesn't present the other side of the debate, that shaken baby syndrome might not be a thing. This is not a case where the Commonwealth puts forward, a lot of the cases in this area are medical examiners, where you have a medical examiner testifying to one thing, and then you have an expert who comes on later on and says, that's not medically supported, there's a completely different explanation for it. Dr. Price says, well, Dr. Block pretty much explained, memory formation pretty well. She explained delayed disclosures pretty well. I would, here are my couple of critiques, which the motion judge said, I don't know that I buy that. But even if there are critiques, I don't think that one rises to the level of manifestly unreasonable to say, hey, I'm riding one horse into battle. They're allowed to do that. He's like, this is the one I'm going to focus on. The jury's not going to buy that.
He's got a child, and his position has to be, this is not true. This child is saying this, but it's not true. I don't understand why the most helpful thing, I don't know if this falls below, ordinary fallible lawyer or whatever. The best defense, it seems to me, would be to put on this expert and say, ladies and gentlemen of the jury, I don't know why this child is not telling the truth. Maybe it's just a lie. But as you've heard from Dr. Price, maybe it's social pressure. They were going through whatever they were going through. certainly by the time of the disclosure. Maybe it's a false memory, as Dr. Price described. You need to know about all of these things, because these are all ways that a child can wind up telling something that isn't true, knowingly or unknowingly. I mean, isn't that a way better defense than he's lying, he's lying, he's lying? Who knows? Maybe the idea was put in his head by his mother.
Well, he did argue that, and he did make sure that the jurors believed. I said 5 deliberating jurors said that the children lie because of social influence. So does he need an expert, or is that just common sense? And
if the other side wants an expert, I'd want an expert too. Right. I mean, I'm not saying, maybe that's just me,
well,
but if I were defense counsel, I'd always get an expert when the Commonwealth had an expert, because if they think it's something that's worthy of expertise, well, then I better find out something about what expertise shows.
well, and he did investigate the Commonwealth's
No, I
expert.
understand that.
And he had, again, it's a strategic call, whether he as I went back to before, it's not whether in hindsight we would have done something different. Is it completely unreasonable to ride one horse and one horse only into battle? And the case law says it's not unreasonable, that you want to preserve, if you want to preserve, because there are other cases where I think
That's when there are alternative arguments, one horse into battle. I don't see why these are alternative arguments.
Well, right.
Exactly, right. I mean, the bottom line is this untruthful words are coming out of the mouth of these children.
Just ask a quick question.
Yes.
If counsel had filed a motion for expert funds, is that a high burden to get over? If he'd said, they've got an expert, I want an expert, would the judge have said, of course you can have an expert?
No, that absolutely would have happened.
Okay.
He could have had it, he just chose not to. If there are no further questions, I'll
All
rest
right,
on my
thank you
brief.
both. Very good arguments, very helpful to us. The case is submitted. We will now take our traditional mid-morning break, and we will return after 10 to 15 minutes to hear the 2 remaining cases. Good morning, everyone, again. The next matter that we will hear is number 25-748. It's an appeal and a cross appeal. And this is SANDQUIST versus BOSWORTH. Some things are impounded. I'm not really sure what they are, but perhaps someone will tell me. We will hear first from Attorney Durland.
Justice Rubin, Massing, Toone, good morning. My name is Sandy Durland of Warner, Federico, and Ryan in Boston on behalf of the appellant. This is a typical appeal from a divorce judgment after a long-term marriage, a traditional marriage, if you will, sort of the breadwinner-homemaker dichotomy. My brief and my client don't challenge much of what the judge found in this case, only her resulting treatment of several key assets in the marital estate, and whether the judge's treatment flows rationally from her findings or whether that treatment adds up, if you will. I have a few comments unless the panel has questions. And I'll start with, there's two components to my argument. First is my appeal, and then with time at the end, I hope to respond briefly to the cross appeal. The first aspect, there were several key assets which were, I believe, erroneously treated by the judge. They fall under three buckets, if you will. Inherited assets and non-inherited assets, if you will. The simplest error, if that's the right way to characterize it, was the adjustment that the judge made in valuing the husband's business interests, which was comprised of a business and a trust holding the property on which the business operated. Through motion practice, post-trial, post-judgment, motion practice, the judge accepted the husband's arguments, revoked some math corrections that she felt were appropriate, and in doing so, changed the value, reduced the value of that business. But in doing so, that delta, the change in valuation, was attributed entirely to my client. And that doesn't seem to square, strike that. It doesn't square with how the judge was treating the assets that she found should be included in the marital estate. And it's I believe it's a very simple issue.
Is there, this was a result of a math miscorrection that the judge made in the first place.
Well, I don't know if she felt that.
She's the one who reduced the value
Yeah.
by the $200 and whatever it is, $91,000 in the first place. She didn't write what the numbers would have been before the reduction, right?
No.
Okay, so
No.
I
So
see.
as I mentioned, she accepted the argument that the husband made through his motions to amend, but it doesn't seem to make sense to attribute the delta, the change, entirely to my client, when by all accounts, all of her findings, all of her discussion was that those assets in the marital estate should be divided equally in an equitable basis. And in this case, that didn't happen.
Did the husband's motion have a number in it? Did the husband ask to have it all attributed to your client, or the husband just said, you've taken this out by mistake?
I believe he was focused on the math error, not the attribution, if you will. Okay. And so my client, I wasn't trial counsel, but trial counsel went back and sought reconsideration. The judge denied that request.
It was the same judge before, right? It was the same judge who had done this, who denied the request?
Well,
No,
the
it was a
trial
new
judge
judge.
retired.
So there was a new judge
It
who
was a new
denied the-
judge, and
okay.
she didn't rule
Yeah, I see.
in a substantive manner. She just essentially said, "My hands are tied. I can't help you." So the issue, that's the issue there, and I think that simply doesn't jive, if you will, with what the trial judge's intent was and what she found.
So could you, I think I understand that argument. Could you go to the inheritance argument? So the judge just excluded all pending inheritances, right? And I assume your argument is that the one that the husband was getting was worth a lot more than the one that your client was getting.
Well, that's true. There's two components. Well, the inheritance,
There's some $20,000 that your
yeah,
client
that
was
was de minimis. That is true. And the inheritance that the husband would get was somewhat uncertain because of a failure to value or place a value on his interest, particularly in the trust that held the interest in a home in Milton, where the husband was living and where he was paying rent.
Do you think the lack of valuation had any bearing on the judge's decision whether to exclude or to exclude it?
Not from my reading of what the judge said. I mean, she certainly acknowledged that the value, there was no value placed on it. But she seemed to focus on the late stage inheritance, if you will, it coming in 2019, in and around the time the parties separated.
After.
Or,
Shortly after the.
yeah, I mean, the timing,
Well, what's the law on that? Because if you have, so if you get a big bonus, right, it comes like the month after the parties split up, that's still attributed to the marital state. But is there actually law dealing with this particular issue with inheritances, where the inheritance comes, 1 month after? I don't know either way, but
Well,
that's different from what what would belong to the marital state. I just don't know if there's actually case law on this issue.
Justice Toone, the answer, I believe, is that all assets, however and whenever acquired, are subject to division. That's the Rice case many years ago, 1977, I think. So everything is subject to equitable distribution under Section 34 of Chapter 208. The judge, however, has discretion to carve out or make exceptions in some manner, and in this case, she found that the timing issue was really preeminent, even though the husband received his interest in the trust in 2015, 4 years before.
But it was revocable.
It was. I mean,
it's like being in a will, right? It's revocable.
It's true. I mean, and I point out, in my opinion, there was a little bit of a disparity in how the inheritance were treated throughout the marriage, and my client's $1 million inheritance coming in later, much earlier, and so forth, and that timing issue. And my estimation should be considered, but...
Can I ask you, I thought I read in one of the briefs that at some point there was some testimony or evidence of a purported asking price or sale price or something that the wife had or had done or said. Do you know anything about that?
Well...
This is of the Milton House.
The testimony about the Milton House was, I believe, given by the husband, and he
says his interest was $200,000. Right?
I don't believe. Okay, I mean that may be your memory, may be better than mine.
It may be. No, this may be a false memory also.
My recollection is that the husband was not certain about the current value on the property, and that he wasn't aware of how the property was valued.
And the wife had no position on...
Well, I think the wife was constrained by certain evidentiary rulings made by the judge.
No, I'm aware of that ruling. So there may be evidence, but it just was never put in because of that ruling.
Well, I can't speak to that, but
Okay.
I can speak to the fact that the husband's financial statements often or almost uniformly had no value. So, and I'm not sure my client was even qualified candidly, to even propose a value.
It's just a house. I mean, it's not the hardest valuation challenge that happens in a divorce case, right? I mean, I don't understand, you can go in Zillow. I know that's not going to be, evidence, but you have a rough estimation of what a house is worth. So I just don't understand the gap here of why wasn't, regardless of all the evidentiary issues, why couldn't some value be placed on the interest, the 25% interest, which was essentially the house?
Well, I mean, that the judge, her finding was that there wasn't sufficient evidence to put a value on the property. And, but the issue, I think, is less about the value of that property, because the judge had other metrics that she could have availed herself of by, when it's sold. If and when it's sold, you'll get a piece or something.
You're
like that.
saying that you understand it to be just it was included in the marital estate, but then
Given all to the husband.
and there has to be case law on this, right? This can't be a novel issue about this kind of circumstance where the inheritance rolls in the month after the parties separate, and does that go to the inheritor, or does it get split between the parties? There's no case law on that at all?
Well, there's plenty of case law. I mean, there's all sorts of case law involving the equitable division of trust interest, beneficial interest, which would be apt here. But it's ultimately up to the trial judge to include it, exclude it, do some sort of...
It's equitable.
It's equitable. Ultimately, it's up to the judge.
Can I ask, because your time runs short?
Yeah.
The golf club membership.
Yes.
The golf club membership interests me. Maybe it shouldn't.
Well, it certainly is among the smaller issues in play here.
I don't understand the golf club membership. Your client wants it because to play golf, or does it help enhance the value of the house that she may or may not sell, or why does she want it? I'll also ask why the husband wants it, but...
Well, here, the judge found that the wife didn't want it, in so many words, but that really wasn't what she testified to. She asked for the property, she got the property, therefore she wanted the membership to flow with the property.
Wait.
Because it does...
Yes, go ahead.
It would speak, that's if you buy a house on a golf course and it has a membership.
But she said she was going to sell the house, she thought. Obviously, she's not bound to do that. I don't know what's happened. But she said she was going to sell the house. The only evidence I see is that this membership can't be sold. But does it run with the property, or does it run with the people?
I believe there's a link to the property.
Is that in evidence?
Your Honor, I'm not going to...
Is the membership in both of their names? You don't know?
I did know. I can't say as I stand here.
I just can't understand. I mean, first of all...
It's a link. That's a good pun.
if they're both using it, which it sounds like, it's not clear to me why they can't both use it after they're divorced. I don't understand what this is exactly, but maybe there's just no evidence about it.
Well, it certainly was a minor issue, and my client wanted the link to remain because she received the home, and there's a benefit in having the membership with the home.
If it's saleable.
I don't believe you can be a member without being I take that back. I think there is benefit linked to the home ownership and the golf membership.
Okay, but you don't think there's any, you can't point me to some evidence in the record that says that?
Beyond my references in my brief, no.
Okay.
Can you tell me a little bit, can you address the valuation of DAB company with assuming, so the judge did not accept for alimony purposes, this is their counterclaim.
Okay.
The double dipping. The judge did not accept for alimony purposes the $270,000 that the expert said was the reasonable executive compensation. So if we think that, so why shouldn't the value of the company, if his salary is $800,000, why shouldn't the valuation of the company be reduced reciprocally to that?
here, the judge chose not to, I mean, the double dipping argument, which is what I believe Your Honor is talking about, he retained the interest. He was the he was the shareholder in this S corp.
Right. He
He
gets the entire $279,000 value. That's his asset.
That's the income his expert used in valuing the business. But there's
Sorry, $2,759,000. That's the so it's about a tenth. Yeah. So if he's going to, so should the valuation of the company, to avoid double dipping, should the valuation of the company be less because the salary's more?
Neither one of us are challenging the valuation of the company. The issue is whether or not somehow there is this double dipping issue. And here, the findings are clear that the $270,000 income level, the normalized income that the expert used, bore no relationship whatsoever to the income that was available through this company, which the husband owned for purposes of this very opulent lifestyle. And the distinction is, and I point this out in my brief, the distinction is here, the judge found it more equitable to take an average of the 2018 through 2021, I believe, a four-year average at 800,000 or slightly more than that, because that was more realistic insofar as the lifestyle is concerned. And since the husband was retaining the asset, I don't believe the double dipping argument necessarily applies. But in any event, that's also not a hard and fast rule. I mean, trial judges can apply double dipping or not apply double dipping. And in this case, the equities and the findings support the decision that she made to use a higher level of income to calculate alimony, in this case, to maintain the lifestyles.
Okay, your time has expired, but it's a complicated case, so if there are more... No, I see none. Thank you very much for your argument. We will hear next from Attorney Novich.
Good morning, Justice Rubin, members of the panel. My name is Attorney Richard Novich. I represent Charles Bosworth. With me is my colleague Gary Todd and Megan Rothmich. They will not be arguing. I will be taking the laborer today. I'd like to start by answering some of the questions that your honors have asked over the past 15 minutes or so. And I'll start with you, Justice Rubin, relative to did husband have a number in his proposed judgment? You were talking about the 937 and the adjustments made to the husband's business on the post-judgment motion for relief. The answer is yes. As part of the proposed judgment that we filed at the time of, or at the conclusion of the trial, the number or the cash dollar amount that we were seeking to be transferred from husband to wife was around $917.
I'm asking about the motion to correct the mathematical error.
It did not.
It did not. All right. So that's the answer to my question.
Okay.
Do you want to talk for a few minutes about the, I know it's the least, it's maybe not the least important thing, the golf club membership?
I wish I had something intelligent to add to that discussion, Judge, but unfortunately I don't. I can't provide you any evidence in the record. I'm not aware of any specific evidence in the record.
About how it operates, whether it goes with the property, whether it can be sold, nothing.
The only thing I can tell you is from the judge's findings, which say that the value of that interest is worthless.
So you find, your position is it's valueless.
Not my position. The judge made a specific finding.
Okay, so why don't we give it to the wife? It's not worth anything.
Well, the judge found that
it's valueless. Why don't we give it to the wife? She seems to really want it, right?
So the issue is my client happens to actually use it in golf.
Does he live in Naples anymore?
I'm not sure if he lives there or not, but he certainly likes to golf.
He's entitled to go and play?
Yes.
So it has some value.
So it has some intrinsic value, not necessarily.
So it does have some value. He wants it and she wants it, and presumably
So you don't have to live in the house to use the golf course?
I can't answer that with any degree of certainty, Your
Are
Honor.
there
I wish I could.
Airbnbs down there? Or, I mean, where does he stay if he's going to use the golf membership if he doesn't?
I'm sure that there are lots of
He
places
has plenty
to
of
stay.
dough, so.
Let me address your question, Justice Toome. You asked a question before about there's got to be cases about the receipt of post-separation inheritances. The answer to your question is yes. One case that comes to mind off the top of my head is a case from, I think it was 2015. I was involved in Alexander versus Alexander. Mr. Alexander in that case received an inheritance sometime after the parties separated. The trial court judge awarded the entirety of it to the recipient and then divided the marital estate differently.
But in that case, it wasn't included in the marital estate. It was outside the marital. Isn't the problem here that the inheritance gets taken into the marital estate, but then it gets equitably divided? And if that's the case, I understand there's a lot of equity that a trial judge has to divide assets up. I just don't quite understand how it's different from a bonus that arrives the month after separation, which would normally be attributed to the parties' relationship prior to separation. Do you see what I'm saying?
Yeah,
Why are these two things treated differently?
So some of the analysis would be found in the Alexander case.
Okay.
Case law, there's Adams versus Adams, there's Williams versus Massa, and they deal with trial court judges, the discretion, the ability to consider the genesis of the asset, the bloodlines that are involved in it, the timing of the receipt in particular, whether the asset was interwoven into the marital fabric or kept separate or commingled, whether the parties relied upon it coming in and what they did in reliance on it.
I mean, the wife has an argument, well, I had $1 million inheritance, and that got kind of absorbed into our joint assets, right? And why is this separate asset treated differently?
Sure.
Even though it comes only, just after the separation.
Sure, great question. Again, the case law, I think, pretty clearly spells that out. The timing of the receipt can be considered by a court. The court is not required to consider a pre-separation receipt of an inheritance, the same as they consider a post-separation receipt of an inheritance. Adams versus Adams, Williams versus Massa, and there's some others that we cite in the brief. What the judge did here in treating the two different inheritances differently is entirely supported by the case law, some of which I've just provided you. The other ones are in our brief.
Why wasn't the asset valued? I don't understand.
Why
couldn't they put a value if the DJB trust was essentially this house in Milton?
So a couple
couldn't a dollar figure be put on?
So a couple of reasons. Let me answer that in two ways, Judge. One of the very first financial statements that was filed in the case, and if cited in the brief off the top of my head, I don't remember, but it's the Record Appendix 5. The value of the home was estimated at $200,000. I believe you, Justice Rubin, made a comment about that. That's found in our brief, and that is set forth in our client's financial statement. That was
$200,000 house in Milton?
He has a 1/4 interest in the house.
An $800,000 house in
Apparently, yes.
Okay.
Apparently, yes.
Take judicial notice. I don't think that exists, but we'll go ahead.
I bet there's one.
The second answer to that, Judge, is that the asset, from what I understand, was still in probate, and it hadn't gone through the probate process yet. So it hadn't been distributed, it was inchoate, and he hadn't received it yet. But nevertheless, some value was ascribed to it. Clearly, I think that was an oversight on the trial judge.
Do we know how much rent he's paying?
Off the top of my head, I can't tell you that.
Is it in the record, you think?
I believe it should be.
Okay.
All right.
I want to talk about the double dipping.
Yes, please.
I don't see any double dipping here. Let me tell you how I see it. You tell me why I'm wrong.
Love to.
They value it taking out what a reasonable CEO would take, $275,000. Why is that the value? Because when they sell it to someone, that person's going to be a reasonable CEO and take $275,000. But during the course of the marriage, this couple were unreasonable CEOs, and they took $800,000 every year.
Okay.
And so that's the basis of the alimony. But if he sells it, he can still get this value for it.
He very well may be, but what I would say is the fly in that analysis, Your Honor, is the D'Alessio case, the Trethewey case, the Sampson case, and the Adlaka case.
Well, they're not exactly the same as this.
I think Trethewey is as close as possible on it with respect to how this court handled what the trial court did in that case. There was one
But
asset.
I'm asking you, is it double dipping? Doesn't it in a way make sense to count it this way?
So according to the case law, and as a matter of equity, the answer in my view is no, it's not, it doesn't make sense. It's it's inequitable.
What if we had given, I understand that he'd just sell the business or move his operations to another business or whatever. Let's assume he wasn't allowed to do that. We could have given this company half and half to these two people who are now divorced. It's a pretty bad idea. But then each of them could have taken out 400 grand every year as long as they owned it.
Theoretically.
Would that be better?
I think it would be a bad idea like you
I think it would be a bad idea, but wouldn't it come out actually worse for your client than this alimony?
In the long
Because
run-
of the cap on alimony?
I think in the long run, given the likely litigation with derivative shareholders.
No,
suits, it would
look,
probably be
I
bad
don't
for both
know
of them.
who the shareholders, but I'm just saying in terms of sort of the equities of it, in a way, isn't that what you're trying to replicate?
What I'm.
Both of them owning it and each of them taking the 400 grand?
So that's not what the trial judge did here.
No, I agree with
Right?
that.
So the trial judge here adopted in its entirety the expert report of Mark Bello. Found his analysis sound in all respects. He followed Bernier, he did the fair value, he did everything that he was supposed to do. She then credited the $270,000 carve-out, if you will, of the reasonable compensation for the owner. As part of that process, Mr. Bello then carved out a separate portion of his income to drive the value of the business. What this judge did is she disregarded the carve-out. She disregarded what I suggest is the admonitions or the disfavored way of handling this set forth in D'Alessio, and she considered all of his income, including the amount that Mr. Bello utilized to drive the value of the business. And under the case law, I believe it's very clearly there was a double dipping there. She used the same dollars twice to divide an asset and then determine income for purposes of support. No way around that. I think, and I don't believe that she was apologetic about it. She admittedly done it, believed that she was doing the right thing. I believe that it was contrary to Massachusetts law in the cases that we've cited.
Can I ask you another question about that? The judge made some findings about the husband's draw and the actual income that he's getting, and she says it's around $400,000 a year.
I beg your pardon, I didn't hear the beginning.
The judge made some findings about the draw that the husband's getting, about his gross weekly income. It comes to about more like around $400,000, not $800,000.
Yep.
So he's not getting a salary of $800,000 from DAB. He's getting more like $400,000. Where does the other $400,000 of income coming from?
So, great question, Judge. I think the way that the trial court judge derived the 800 was using a 4-year average of the income and profits that were received from 2018 to 2021. The number that you're thinking about what came out of a financial statement that was from 2023. So from 2021 to 2023, his income dipped a bit. That's the ideology of the deficiency and where you're coming. What I would say is, if, to Your Honor's question about the double dip,
Okay.
one way she could have avoided it, most respectfully, is if she wanted to take a 4-year average, and I found no cases that said that that would be an abuse of discretion. She's clearly warranted in taking an average of someone's income, especially one that fluctuates as here. She takes those 4-year average, reduces it to $800,000. To avoid the double dip, all she needed to do was carve out the money that was, or the earnings that were utilized by the expert in valuing the business, $367,000.
Sure, and then when he sold the business, he'd get the higher value because a reasonable CEO would only take $275.
Most respectfully, I can't predict what the future is going to hold.
I can't.
And whether down the road he's going to get more or less. I've seen it both ways. So
Sure.
I hear you.
And I'm not saying he's ever going to sell the business either, because it's a going concern of real value, obviously.
So what would, if we did do it your way, what would the value be of the company?
I can't tell you that. Right now we have, Mark Bello has valued the company, I think it's $2.7 million.
Mm-hmm.
I think really what you're faced with is two options. Either the value of the company is artificially inflated, or the value of Mr. Bosworth's income is artificially inflated. He's either going to pay too much in support to his former spouse, or he's going to pay her too much by way of an
What
asset.
if the valuation had been done by another method?
I'm sorry?
What if the valuation had just been done by another method?
Then we would
and
probably...
and come out the same?
So let me address that. If the valuation had been done in using the asset approach, we would not be having this conversation. Champion versus Champion addresses the asset approach, right? Assets plus receivables less debts equals the value. Under the Champion case, what happened there was that's exactly the valuation method that was used. The trial court judge then used 100% of the business owner's income to determine their support.
How do you figure out the asset value without looking at earnings?
With the asset approach?
Yeah. You mean if it was literally if they just sold the chairs in the office and if they have any lumber, sell that? So it's $18 or something?
I'm going to try to stay in my lane. I'm not trying to pretend that I'm a Mark Bello here, but what I understand the asset approach is that you simply look at the assets of the business, the cars, the trucks, the land, the tools, what have you. What are the accounts receivable? You add those together, you subtract out the debt, and that's the value. Income is not part of that equation. So under the Champion case, which is why I think this court found that...
And that's a valid way to, I mean, when people value companies, don't they usually use like EBITDA or something, right? It's all about earnings, isn't it?
So to value companies, again, as I understand it, the EBITDA, I think is how it's pronounced, is certainly one of the considerations. But as far as the methods that are utilized by the experts, there are three. There's the income approach, there's the asset approach, and then there's the market approach. And in this instance, Mark Bello considered all three. He considered the asset approach. He found it not to be worthwhile. The judge credited him for that. He looked at the market approach. He didn't find that was going to be appropriate. The judge credited that.
Did he testify to numbers of those two approaches?
His report may have identified some, but I don't believe so. The only approach that he found to be particularly relevant and helpful in this instance was the capitalization of earnings approach. The judge credited it in its entirety, and it was fully sound. And I think once she did that, as part of that analysis, Mark Bello was required, pursuant to that analysis, to subtract the reasonable compensation that you and I have talked about. In doing that, Mark Bello very clearly, under the principles established by D'Alessio, established two separate portions of my client's income to be utilized. One portion drove the value of the business. The $270,000, or some variation thereof, could have been used for purposes of alimony. This judge added them both together and ordered alimony to be paid on both. And I think based upon the cases we've cited in the brief and the ones that I've highlighted for you today, I think that was improper.
You got 20 seconds.
Oh, yeah, I've got, no, I have a question, sorry, I have a question.
I thought I was over by 20 seconds.
Have you, you have a kind of, I don't know, snarky footnote about you were offered to explain to counsel how the asset division worked. What's your best chart? Do you have a chart of the asset divisions in here that sort of echoes what the judge did?
Yeah, so the very first one, I believe it's at the addendum at page 113. That's the purest. And that results in roughly a 52-48% split. That does not include, Your Honor, the value of our client's inheritance.
Do we know anything about what size the bank accounts were? She makes some vague reference to certain small bank accounts that will also not be divided. Did she write anywhere which ones she meant or what their values were? A couple of them don't have any values on them at all.
So the short answer, Your Honor, is there were some references in the findings, but the judgment does not identify which ones are which or what values are ascribed to those particular assets.
So I'm sorry, the chart that I'm looking at here, we only come up with about, this is 113 of your brief, it's about $7 million, not $9 million.
Okay, yes, that's true, but one of the assets on that chart was not included because the goal is to have it sold and the proceeds divided. So because it's unclear how much it's going to sell for. And
this is the Westwood home?
Perhaps, Judge, it was the marital home, wherever that was located.
Yeah, okay.
So that's why it wasn't included.
What's missing from this one?
I'm sorry?
I mean, this is your chart, page 113.
Yep.
The first thing that's mentioned is the Westwood home.
Yeah.
So what's missing?
So the only thing that's missing from that are I believe, three things. One, the value of our client's inheritance, the trust asset, if you will. Because based upon the judge's findings, she said that there was no evidence of value. I believe that was an error on her part, inadvertent. There was a value that was ascribed of $200,000. The subsequent charts include that. The other thing that that one particular chart does not include is the equalization of legal fees. And the equalization of legal fees, I think, most respectfully, should be considered in the total calculus of how this marital estate is divided. And once you factor that into the mix, the percentages fluctuate. And the bottom line,
What were the total legal fees?
hundreds of thousands of dollars. Off the top of my head, I don't remember which, but it ended up having our client reimburse Mrs. Bosworth around $137,000. So that went from his
The big
side.
thing you guys are fighting about here is $145,000.
Well, we're fighting about a valueless.
I understand lots
valueless
of
golf
different things,
membership
but
as well,
like
apparently.
the headline, though, is the 145. And
That was not my main argument.
no, I understand that. But maybe they should have put it in a trust for their kids.
So we ask that the asset piece division be affirmed and the alimony be vacated and remanded for recalculation.
Thank you very much. Excellent arguments by both of you. Very helpful to us. It's a complicated case. The final matter we will hear this morning is John Doe 21527 versus Sorb. This is number 25367. Of course, this is impounded, so we won't use names, except Doe is okay. And we will hear first from Attorney Burkholder.
Good morning, Your Honors. May it please the Court, Fred Burkholder on behalf of John Doe 21527. My case isn't anywhere near as complicated as the ones I've witnessed this morning. My case is about a man who committed an offense 42 years ago and now has been found to have committed a subsequent offense based upon a one-page police report that is questionable. And I say it's questionable for the following reasons. I know you've read my briefs. I'm not going to be repetitive, but supposedly, if the police report is deemed to be accurate, my client visits a home of an individual he had a previous relationship with. The status of the relationship at that point isn't clear from the report. He makes certain requests, demands, and the like. She rebuffs them. What happens thereafter, there isn't really much evidence to corroborate. She refused treatment. There's a slight reference that there might have been a mark upon her, but not much else. What doesn't make any sense is if she contacts her mother and the mother is responsible for reporting to the police, either the mother sat on the information or the Saugus Police Department are the slowest possibly that could exist because they didn't show up until 4 o'clock in the morning. And here's the problem with that. If you look at the first page of the police report, it says, my client's in a pair of shorts, no shirt, and a pair of shoes. What was she wearing? What were they doing? Were they in bed? What do people do at 4 o'clock?
What difference does it make?
Well, it makes a difference because of the following. I think that we have to look at plausibility of an allegation. We have to look
It seems pretty plausible. I mean, you have a lot of inferences you're drawing. What child would be up at 4 a.m. or blah, blah. Well, children are up at 4 a.m., and especially if there's some shouting going on in the house. You know what I mean?
I don't disagree with that, Judge,
hard
but I don't
to-
think this is, you know, I mean, we have no witnesses whatsoever.
No, you do. You have one witness. To the crime, it's the woman who was there.
Exactly. And it's contained in a hearsay report
I
that
agree.
has no other corroboration. And-
Well,
and I-
the officer says she looks scared, and EMTs looked at her for jaw pain. I mean, I understand it is what it is. It's, you know, it's obviously not the most robust description, but it only has to be reliable, and it was a report made to police.
It doesn't even say whether the touching that occurred under or over her clothing. It doesn't say where in the household it happened. It doesn't say.
But we can absolutely draw every inference about that in favor of your client, but it's still, I mean, he was charged, right?
He was charged, she didn't show up, and the assault to rape charge was nollied.
I understand that. I understand that.
I mean, at best, I think what we have here is, and the comment about the clothing was as follows. If there's an allegation that he tried to remove her clothing, but yet later she's found when they arrive without any clothing on, how relevant is that? So
I guess it depends on how she got that way.
well, exactly. But the point is, it's not like the ordinary police report where, incident occurred, the police show up 15 minutes later, and the like. This is, and my problem is this. When you have, and I know that no conviction is required, but when you have a couple who has an ongoing on and off relationship, and you look at the allegations as they're contained, let's look at the impact that it has upon this. We have a guy who otherwise had I'm not saying my guy's a saint. That's not what I'm trying to say. I mean, certainly he's got tons of contact with the criminal justice system. He's got some issues with hostility with women and the like. He's treating them now per his probation officer and per a psychologist. But he's managed to stay away from sex offense conduct for 42 years, but for this incident. That speaks a lot to the issue of deviancy, which is, to me, the most important component of any type of prediction of risk. So it's just one of those cases. It's like the hearing counsel actually contacted me last night to voice her opinion with regards to issues that the Superior Court addressed, which was, you have a 17-year-old who gets involved in a heinous offense, frankly, in my opinion, with a then-girlfriend of comparable age, which the hearing examiner does mention and the like, but then manages to stay out of trouble for all this time, sexually related. Doesn't have any. And now you have this report. I got to say, but for this.
Aren't there two 209As also?
There are, but they're not, 209As are not sexual misconduct. They don't classify as that, and they're not considered by that. In every decision I've ever read, they are not. Certainly it suggests some inability to have appropriate relationships with women and their hostility, but they're not sexual misconduct.
They could be. We don't know, because the third definition of abuse is sexual conduct.
But there should be evidence of it. There wasn't an application. So I have to deal with what evidence that I have, and all I'm trying to say is that I've got one report versus one-page report versus 42 years of conduct that has not been sexually related and isn't even.
Can I ask? I thought that there were 2 phone calls made. Somewhere I'm getting the impression, I don't remember if it was in the hearing examiner's report or in one of the briefs, that maybe she was able to call her mother, but he was listening or something, and then she calls her friend, and it's the friend who calls the police?
Something
or am I
to
making?
that extent. It was a coded message. Let me see. I have it right here. It says, excuse me, 1 second, please. All right. Let me see. I didn't concentrate on that, so I'm having trouble finding it. Where is it? Oh, thank you. Oh, okay, I see. He kept following me around the house, not letting me speak to anybody on the phone until I got a hold of my mother and was able to speak with her with her in code, and my friend was able to call the police department for me. So it doesn't say 2 different phone calls, but it suggests
There must be 2. I mean,
there must have been 2 or otherwise. I usually don't make that big of a deal about credibility cases, and I certainly am fully aware of the deference that this court, as well as the Superior Court, has to give to a hearing examiner. I just think in all the reports I've seen in all the years, this isn't the strongest one possible that exists. So is it enough to keep him as a level 2 based upon the other things that have occurred in his life? I mean, I fall back upon the comment that's made or the statement or ruling that's made, and I think it's 11-204 that says, however long ago in the past that you have a sexual misconduct, you don't remain that way. 42 years is a long time to remain offense-free from sexual misconduct to then be hung with a level 2 based upon this. Fortunately, he's not on the internet. He wouldn't be, if he was on the internet as a result of this report, I'd really be upset. Yes, sir.
He's not on the internet?
No. He was a pre-Mo case, which is, that's what they call them, which is a decision that was issued a level 2 prior to, I think it's maybe 83. I can't remember the exact date. I think it's 83. And there was subsequent litigation that took a look at it and said it would have been, I believe, ex post facto if, in fact, he would have been deemed, and that, am I right, Judge? I thought I was.
Something like that.
The hearing examiner actually does make findings so that it should be disseminated.
Yeah, they didn't understand the law. Nor did, frankly, the hearing examiner, or the hearing counsel also asked for an injunction when on a level 2 there's no basis for an or for dissemination under pre-Mo. So, I mean, nobody was.
And it's not being disseminated?
No.
Okay.
No, it can't be, based upon.
Well, I know it can't, but the hearing examiner didn't know that. I don't know who posts these things and if they know it either, but all right.
I get them afterwards, so I don't know the answer to that question.
Yeah.
So all that being said, and I know it's been a long morning and the like, I just would ask this court to take a serious look at the detail that which is contained within this report, its plausibility, the lack of corroboration, or otherwise the relationship between the parties, the time and the proximity and the like, and say, is it enough to support a credibility finding when you have 42 years worth of offense-free time in the community otherwise?
And can I ask you about your other argument about this, the detail or lack of detail of the hearing examiner's report? You have a very lengthy citation here from an unpublished case that happens to have Judge Rubin on it, lucky for you. But it's over a page of your brief, single-spaced, citing this unpublished case. Is there no published case that stands for the same proposition?
There are. The problem with hearsay evaluation by the appeals court or, frankly, even the Superior Court is Doe 10800 gave the SORB almost carte blanche deference with regards to
No, but
determining.
I think Justice Massing is talking about whether the analysis in the opinion has the level of detail or whether it's mechanical checklist kind of stuff.
You know, Judge, if you could tell me the case, maybe it will come back to me. I don't know if I brought enough of my brief with me to answer your question specifically.
Page 41 to 42 of your brief, you cite John Doe 321579, which is an unpublished decision by Rubin, Nyman, and Ditkoff. And it's
oh yeah, okay.
It's very long.
Okay, I remember.
And I'm asking is there could you not find a published case that says that, or does that panel go a little bit beyond our published cases?
I love that case. I love that case, and I love that case because of the detail that is put in that opinion that talks about the fact that we should go past the deference that's there, and we should say, okay, fine, you have the authority to balance, you have the authority to cite the factors, but you better explain why you're a 2 level 1, a 3 or 2. And that's my argument many, many times, whether my esteemed Justice Rubin is on the bench or otherwise, because I think that's the real problem with the whole system. Is
in addition to the case that's always cited, right, which is the one about checklist
11204
or other reflex or something it says. There is a published case that says, that uses the phrase reasoned analysis.
Oh, yes, of course.
Right, so I think that's where it comes from.
230.
Asking him.
You're really testing my memory at this time of the day, but I think it's 234076 that says that. But that's commonly repeated reasoned analysis. I guess the point I'm trying to make is, you know, when you've got a situation like this where you have the length of time that this man had out in the community not being a saint, but not committing any sexual misconduct. And all of a sudden you say, okay, he's a 2 like he was before, back in 2004 when he agreed he was a 2 back then. Maybe you ought to explain a little more why he's not a 1 versus a 2 or a 3. And that never happens in any of these cases. And then we get down to the issue of why aren't we in a numerical system, which would make it easier. My understanding is Jersey had that, and they even tried it here, and it's a nightmare. So I don't know what the answer is, but to me, there's got to be more explanation. And my sister cites a wonderful case in her brief that says, you don't have to do any of that. What do you want me to say?
Was Justice Rubin on that one too, or was it?
Unless there's nothing further, I rest on my brief.
You said they never?
There's a citation in my sister's brief that says it's enough that they did this. No further explanation is warranted. I didn't bring that page with me because it didn't really sit well with me. So, and she's the first one that I've ever had an argument against that has found that particular citation. I'm hoping no one else does. Unless there's any further questions.
Judge, all good? I see none. Thank you very much. We will hear now from Attorney Marini.
Good afternoon, Your Honors. May it please the Court, Nancy Morency, appearing on behalf of the Sex Offender Registry Board. This case really just comes down to whether the hearsay evidence of Doe's sexual misconduct was properly admitted. And I submit that it was properly admitted and then properly applied under the Board's regulatory factors that supported finding that Level 2 classification. He is not being disseminated, as Attorney Burkholder has stated. In the decision, page 8, it cites that since he was classified as a Level 2 sex offender before July 12, 2013, based on the SJC case, he will not be disseminated. So hearsay evidence is admissible if it's credible and reliable. And in this case, the hearing examiner found that the allegations of Doe sexually assaulting the second victim to be credible and reliable by a preponderance of the evidence. And he made detailed findings in that regard. He credited victim 2's detailed account, which included the police report and the victim's statements, and they were consistent with each other. He credited that Doe punched the victim in the face after a request for sexual intercourse was turned down. And this is further corroborated in other evidence in the record showing that Doe has struck a woman in the face on a couple other occasions as well. He also credited that Doe tried to force...
I'm not sure that corroborates that he did this time, but go ahead.
But it shows that it's not unreasonable for Doe to strike a woman in the face.
That's
when
propensity evidence, but all right.
And there's other evidence where he's...
No, I think there might be other evidence.
So all of that compiled with the consistent statements of the victim's report, the police report, the victim also was shown to be very scared of Doe, and that is potentially why that she did not prosecute this case and why it was ultimately dismissed. It doesn't mean it's unreliable because he was not convicted of it.
Can we talk about the second argument that Justice Massing brought up about the reasoned analysis of the hearing examiner?
Sure.
How is this adequate?
This is adequate because the hearing examiner shows how each factor was applied based on the evidence that supported that factor.
And then after that, what was the reasoning for why that leads to a 2? Right, there's maybe one high-risk factor, a bunch of risk raising, whatever the right word is, factors, and then there's mitigating factors. And I agree with you, the examiner takes care to go through each one and to say, in some of the cases, and moderate weight, full weight, and so on. How does that get us? Where would I look in this hearing examiner's decision to see why at the end of the day that makes it a 2 and not a 3 or a 1?
Well, that's the hearing examiner's discretion. They are imbued
Yes,
with that
but they have to
expertise.
give reasoned analysis, as
Right.
I understand it.
And that's what the entire decision is. It's
No,
here's the
I'm
evidence.
asking about this particular question. why does this many, or not this many, these particular factors and these ones, in my expert opinion, result in a 2?
Well, it's not a tally system, so you can't say
Oh,
that.
you can't tally. I agree. You have to reason.
Right.
Okay.
And that's what the entire decision, when read as a whole,
Well, here's what I
encompasses.
see. I see, under risk of re-offense, I believe the analysis is, this is on page 25 of the hearing examiner's report, based on the above factors, I find by clear and convincing evidence that the petitioner's risk to reoffend is moderate. That's the analysis here. And then with respect to dangerousness, I find this conduct and the applicable factors to be indicative of the petitioner's moderate degree of dangerousness. And I'm asking, how can that be enough? Doesn't the hearing examiner have to say something? If we had replaced the word moderate with low or high, right? You'd be here saying the exact same thing, right? These are the exact factors, and he concluded it was, or she concluded it was high.
But that's
Don't they have
just-
to explain, in the end, I think this outweighs that. A particular concern of mine was this factor, which I gave heavyweight. And although there's this, I really felt at the end of the day that, that wasn't enough to really push me, something that shows something other than just finding which factors applied.
Well, so the statement, I find by clear and convincing evidence that the petitioner's risk to reoffend is
How do I
moderate
know
is
he
a
didn't just
concluding
count?
sentence.
How do I know he didn't just count the numbers? Oh, 8 of these and 4 of these.
Well, you can try to compare all the other cases of, okay, this one has 1 high risk and 10 risk
Yes, we
elevating.
could
That's
compare
not-
all
that
the
would
other
be-
cases, but since they're arbitrary, that's going to be quite tricky, in my view, because I see cases where people come in and are 3s, I see cases where people come in and are 2s, and they can be virtually identical.
Right, but
I mean, I've
all-
been doing this for like 15 years. I see this every week.
Well, that's where it comes down to the hearing examiner is imbued with that expertise, and it's a qualitative analysis
Well,
based
then
on
they
the
should
evidence
be
applied
able to
the factors.
explain their expertise and the quality, and this is the least analysis I've ever seen.
But it doesn't,
It's just a sentence saying, looking at those factors, I conclude X. That's not reasoning.
but it's not just this taken in a snapshot. It is the entire decision where he goes under each factor. So these factors were further detailed earlier in the decision. So factor 2 with increased weight applied, but he didn't just cite it in risk to
And so that's
reoffend.
enough
It's
to outweigh whatever the mitigating one is. Would it not have been enough if it was only moderate, or it still could have been enough?
For the, I'm sorry. I don't
Come to a
understand the question.
conclusion that it's moderate risk. How much of a role did that weighting play in his analysis?
The weighing of all the factors is the entire analysis on how he gets to the moderate risk to reoffend. So,
But shouldn't you have some kind of, not just a conclusion, but some kind of, summary of the totality of the factors that have been analyzed and sort of a weighing and a reasoned explanation for why you come out with moderate at the end, right? And it doesn't seem quite sufficient to sort of point back to the other factors if you don't have one paragraph that's kind of putting all the entire picture together and arriving at the conclusion, right? That seems to be what's missing here.
I believe that what that part is, it starts on page 23 of the decision, and that's the discussion section. So that's where the hearing examiner summarizes the totality of the case, and then he goes under each specific finding that he's required to find, the risk to reoffend, degree of dangerousness, and publication. Then he goes into which factors were applicable based on that. So all of that is encompassed within the decision.
So all you have to do is find which factors apply, and then bam, here's your conclusion.
It's not that simple, no.
Well, shouldn't you spell out what you're doing
Well,
so
he
we
does
can
do
review
that
it?
in the decision. So under each factor, he says, this is the evidence that applies to this factor, and this is why I'm going to give it this much weight. And that analysis is shown by the weight that he applies to those
And how
factors.
much weight did it need to overcome these factors and be a 2, not a 1?
Well, there's not a strict rule saying you need to have this many. So that's where the qualitative analysis comes in.
Yes,
that he's
qualitative, though, means you have to look not just at the numbers, you have to look at the quality of all of these. But he doesn't say he's doing that. He just says, based on these factors, I find X. Is that what they're supposed to do?
That is enough. Per the case law, that is sufficient to show that he made that reasoned analysis. There was no clear error here.
Okay, tell me the reasoning. Reasoned analysis, what's his reasoning?
It's
Why
shown
isn't this a
within-
1?
It's shown within the 29 pages of the decision of,
So you can't point me to his reasoning? Or
Because
just tell me it.
there's not one specific thing. I mean, significantly, what happened is this hearsay misconduct that occurred. So maybe it would be a very, very
Sure, now
different
this is
case.
9 years after that. You think if it had been 10, he would have said 1? 10 years offense-free in the
If
community,
there
do you
was
think
no
that?
sexual misconduct incident, maybe, and then
Maybe.
yes.
But 9 years isn't good enough.
I mean, it shows the offense-free time that Attorney Burkholder is referencing. There is a board's factor that addresses that, but he reoffended here. So because of that,
But it's
the
nine
clock resets.
years since that. When this was decided, it had been 9 years ago. 2012 was that event, right? The hearsay event?
The second incident was,
2012.
he was, yes, 2012.
Okay,
and
it's
the decision was
2026 now. That's 14 years ago now. So if he comes in today, will he be a 1?
You would have to go through that qualitative analysis again.
I see, but
I
wouldn't
can't
you
say.
want someone to explain, I see it's 14 years, but that's not good enough here because da-da-da-da-da-da, continued contact with the criminal justice system, something.
Well, he does do
But
that.
he says why 9 years isn't enough?
No, that's just one factor in the qualitative analysis. So he gives him, under each factor, that's one of the mitigating factors, but that's just one factor. That's not going to outweigh
Well,
that he
there are studies
reoffended.
showing that after 10 years, it's the same risk of reoffense as a non-offender, I thought. Aren't there? Or maybe that's 20 years. There's some articles about this that the factors are based on.
Yes, that factor, the risk goes down significantly, but that doesn't mean once you hit 10 years, you pose no risk and there's no other.
No, you might pose a low risk.
But that's not how the board's regulatory factors operate. It's that qualitative analysis of all the applicable factors. It's not one factor is going to overrule all the others. That's not how they're designed, so.
Well, at the end of the day, one of them might. Last weekend, he committed a sex offense would probably outweigh anything, you know.
Well, I mean, that would probably trigger a significant more factors then that would then be considered and applied. So it's not, again, not one factor that's going to overrule everything here. And that's where that qualitative analysis comes in. So you go through each factor, you apply the evidence based on the factors, and then you then carry that over to the discussion and then the sections of risk to reoffend and degree of dangerousness, and that's where you get that reasoned qualitative analysis. And everything that's in this decision, there was no errors, and it does show that he considered all the evidence. There was no errors, and there was sufficient to lead a reasonable person to say, yes, this warrants a level 2 classification. He also raised the issue of what sexual crime he would commit if he reoffended. That's also addressed in the decision, considered both the sex offense and the sexual misconduct. So the decision encompasses everything.
And which
here.
offense did he think he was likely to commit?
He just said he would reoffend against women or girls.
Would it be rape like the first crime, or it would be indecent touching of a breast like the second?
Well, based on the facts of the second one.
Because the dangerousness is different, presumably, of those two crimes.
Right. So the victim in the second offense said that she thought that he was trying to rape her. So presumably.
So because
it
of
would
her
be-
subjective thought, he thought, I mean, you say it deals with what the offense will be. I actually think the statute says the offense is the one, the index offense, I think. I may be wrong about that, but that's my recollection.
It's the index, but it's also the most recent conduct is more likely to be what would be the reoffense. Case law says that as well. So
496501 says that the hearing examiner must consider the nature and type of offense that offender would likely commit. Here, the hearing examiner says, well, if he offends, it will be likely against girls or adult women. Is that sufficient to sort of satisfy that requirement?
it doesn't, it satisfies it. It's not specific saying he will rape a woman. I mean, that's not.
Does it say
he doesn't have
he'll
to.
commit rape again?
It says if he were to reoffend, where
Yes.
his governing sex offense was a sexually violent offense and it was a contact offense, then he most likely would have.
So you think that it's the second crime he would reoffend?
That is what case law says the most recent second offense is what you should look at in order to predict. That has more telling, I guess, is what it is, especially where there is such a time gap here. That'd be more inclined to, but it doesn't say he's not going to reoffend how he previously did as well. It's all within that analysis. So the hearing examiner includes both, saying if he were, it would be against
He includes
girls or
both, he doesn't include either.
Well, he says
If he were to reoffend.
it would be against women
I
or
agree
girls
with that,
he
but he
meets.
doesn't say what the offense would be.
Not specifically, no, but he doesn't have to. That's enough to say that if he were to reoffend, then it would be against them, as he previously did. And I see I'm running out of time, so if there's no further questions from your honors, I will rest on the board's brief and ask that you uphold level 2.
Questions from our honors? You have no more questions? All right. Thank you both very much. Very helpful arguments. The case is submitted. This brings us to the conclusion of our sitting for this morning. I'd like to thank the court officers and the court staff for their, as always, excellent assistance. And we stand in recess.